Notice this judgment was delivered in private. The judge has given leave for this version of the judgment to be published on condition that, irrespective of what is contained in the judgment, in any published version of the judgment the anonymity of the children and members of their family must be strictly preserved. All persons, including representatives of the media, must ensure that this condition is strictly complied with. Failure to do so will be a contempt of court. Case No. CM 18F02685 in the Family Court at Chelmsford. Date: July 10, 2019. Before. Between. H.J. Lochrain. Mother applicant and father. Girl, boy 1 and boy 2 by their children's guardian Ms. R.W. First respondent. Second respondents. Mr. Foster for the applicant, Mr. Father in person, Ms. Thorne for the second respondents. Hearing dates: 8th, 9th, June 12, 2020. Judgment. Final. Numbers in are bundle page numbers in the typed numbering. H.J. Lochrain. This is the judgment at the conclusion of a 3-day fact-finding hearing which has taken an inordinate amount of time to be heard. The applications before the court relate to 3 children: girl, DOB 06, boy 1, DOB 08, and boy 2, DOB 11. Their parents separated in 2018 in circumstances which feature centrally in this litigation. The children have been the subject of proceedings ever since. There are cross-applications for live with and spend time with orders. The children are represented by their 16.4 guardian, Ms. R.W. She is the second guardian appointed in these proceedings to represent the children. In circumstances which I hope will become clearer in the course of this judgment, girl lives with her father and currently does not see her mother. Boy 1 and boy 2 live with their mother and have been seeing Mr. Father in a supported/supervised arrangement fairly consistently, although not without disturbances. Mr. Father has represented himself throughout. He is an articulate and intelligent man who has clearly carried out some research into the law for the purposes of these hearings. Ms. Mother has occasionally represented herself, but at this hearing has been more than ably represented by Mr. Foster of counsel, and the children's guardian has been represented by Ms. Thorne of counsel. There are schedules of allegations on both sides which have been the focus of this fact-finding hearing. I remind myself at the outset it is for the party who brings the allegation to satisfy me on the balance of probabilities the evidence supports the making of the findings sought. The allegations on both sides include domestic abuse and coercive or controlling behavior. The provisions of PD 12J of the FPR 2010 draw the court's attentions to the following definitions. Domestic abuse includes any incident or pattern of incidents of controlling, coercive or threatening behavior, violence, or abuse between those aged 16 or over who are or have been intimate partners or family members regardless of gender or sexuality. Coercive behavior means an act or a pattern of acts of assault, threats, humiliation, and intimidation, or other abuse that is used to harm, punish, or frighten the victim. Controlling behavior means an act or pattern of acts designed to make a person subordinate and or dependent by isolating them from sources of support, exploiting their resources and capacities for personal gain, depriving them of the means needed for independence, resistance, and escape, and regulating their everyday behavior. Government guidance addresses factors affecting the seriousness of the behaviors. Domestic abuse offenses are regarded as particularly serious within the criminal justice system. Domestic abuse is likely to become increasingly frequent and more serious the longer it continues, and may result in death. Domestic abuse can inflict lasting trauma on victims and their extended families, especially children and young people who either witness the abuse or are aware of it having occurred. Domestic abuse is rarely a one-off incident, and it is the cumulative and interlinked physical, psychological, sexual, emotional, or financial abuse that has a particularly damaging effect on the victims and those around them. 9 cases in which the victim has withdrawn from the prosecution do not indicate a lack of seriousness, and no inference should be made regarding the lack of involvement of the victim in a case. The standard of proof is the balance of probabilities, as set out by the House of Lords in Re B. Care Proceeding, Standard of Proof, 2008, 2 FLR 141. In the words of Lord Hoffman in Re B, which apply to serious sexual and physical abuse and assault as they would to any finding of fact, if a legal rule requires facts to be proved, a judge must decide whether or not it happened. There is no room for a finding that it might have happened. The law operates a binary system in which the only values are not and one. Any finding of fact in private law or Children Act 1989 proceedings, and in all civil cases, must be based only on the evidence. As Lord Justice Munby, as he then was, has said in Re A Child, Fact-Finding Hearing, Speculation, 2011, EWCA Civ. 12. It is an elementary proposition that findings of fact must be based on evidence, including inferences that can properly be drawn from the evidence, and not on suspicion or speculation. I further remind myself, if I were to find a party has not been truthful about one or more things, that does not necessarily mean he or she has not been truthful about everything. As I have said, the parties each make allegations against the other. They are contained in 3 schedules. Ms. Mother's initial schedule contained 9 allegations. She subsequently obtained permission to file a further allegation in a supplemental schedule. In the course of the hearing, we have referred to the latter as her allegation. There is evidence relating to a further incident involving a process server in the course of which Mr. Father is alleged to have behaved particularly badly in front of girl. This did not feature in either of the schedules on behalf of Ms. Mother, but I took the view that, from the children's point of view, it was an incident which, if it played out as described by the process server, would have had an adverse impact on girl emotionally, and might give an insight into some of the other allegations. I decided it should form the subject of an allegation to be determined by me, Mr. Father disputing substantially the version given by the process server. For ease of reference, it being an incident upon which Ms. Mother to some extent has relied upon, this has been referred to in the course of this hearing as Ms. Mother's Allegation 11. Mr. Father in his turn has produced a schedule of 7 allegations. The central catalyst for the disputes between these parents is the decision by Ms. Mother in the late summer of 2018 to end her long relationship with Mr. Father. According to her, a relationship with a long-term family friend, New, which had previously been platonic and supportive, subsequently became romantic. Mr. Father remains convinced this was an affair which predated the formal breakup of his relationship with Ms. Mother, and was indeed the catalyst for it. Ms. Mother and Mr. New have subsequently set up home together with Boy 1, Boy 2, and, more recently, their own child Boy 3. Mr. Father subsequently took the view that girl had disclosed to him she had been the victim of sexual abuse/assault by Mr. New. This forms one of the allegations made in these proceedings by Mr. Father. Since that time, Mr. Father has conducted a sustained campaign to have Mr. New recognized and prosecuted for what Mr. Father says Mr. New is, a pedophile who has groomed and assaulted girl and other girls. Whatever the truth of these allegations, and I shall come to that in due course, it has been abundantly clear from my earliest involvement in the case that Mr. Father harbors and has nurtured what has become a visceral hatred for Mr. New. It is apparent this postdates the breakup of his relationship, although elsewhere Mr. New and Mr. Father are described as having been good friends. Mr. Father was at least prepared to acknowledge that prior to the breakup of his relationship, Mr. New was a friend of the family who Mr. Father at the least tolerated. Some evidence, in part from Mr. Father himself and girl, seems to indicate the relationship between the two men had been somewhat closer than Mr. Father is currently prepared to accept. Mr. Father's narrative has developed to the extent he now maintains all children, and particularly his own, are at risk from Mr. New's predatory attentions, and Ms. Mother, by her support for Mr. New, her denial of Mr. Father's allegations and her attempts to retain in, or return to, her care all her children, is complicit in the abuse. Despite the agreed fact that Mr. Father was accepting, and he might be said on the evidence to have been encouraging, of the decision not to conduct an AB interview of girl for the purposes of the investigation into the allegations against Mr. New in the period after the breakup, Mr. Father has more recently, on more than one occasion, sought to persuade me that girl should have been permitted to give evidence before me. Ms. Mother has always taken the view that girl's allegations have throughout been the product of her father's malign influence, and that Mr. Father has shown little or no compunction in using girl and the other children to prosecute his campaign of revenge against Mr. New and her as responsible for the breakup of his family. One of the allegations in her schedule relates to the suggestions that Mr. Father has isolated girl and manipulates her against her mother and others. The possibility that Mr. Father is using girl to further a malicious and/or false agenda has been of concern to both the children's guardians and, more recently, to Dr. H.W., the court-appointed psychologist. All three have, however, been clear the picture would be quite different if the allegations against Mr. New were found to be supported by the evidence. Having consulted the children's guardian on the question of girl giving evidence, and taken into account the former's strong opposition to the proposal, her access to girl having been restricted, I have consistently taken the view it is neither in girl's welfare interests, nor in the interest of evaluating the evidence in this case, that she should be subjected to the ordeal of giving evidence in her father's cause against her mother and her partner. Of one thing I am clear, despite Mr. Father's protestations, her involvement hitherto has been prompted or initiated by the child herself. Girl has been far too closely informed about and involved in the disputes between her parents. At the very best, from his point of view, Mr. Father has failed to shield her from and discourage her from getting herself involved in the consequences of the breakdown of her parents' relationship. Earlier in the proceedings, in light of the then allegations and the evidence in support which each parent indicated he or she might marshal in support, I took the view each party should be limited to 3 witnesses in addition to him or herself. I requested Mr. Kemp, the process server, should be called, and so did not require him to be included in either list. Subsequently, Ms. Mother obtained permission to submit a further allegation in relation to an incident earlier this year, Allegation 10. Mr. Father was, accordingly, given the opportunity to submit evidence upon which he might seek to rely in refutation of the allegation. Prior to the hearing, he did not avail himself of that opportunity. In the course of the hearing, I have heard evidence from Mr. Kemp, the process server, the parents, Ms. Mother and Mr. Father, and Mr. New. Ms. Mother has filed statements from other witnesses who, on her account, have declined to attend, having been subjected to intimidation from Mr. Father. Mr. Father denies the suggestion and challenges their evidence. Mr. Father filed statements from 3 witnesses whose evidence, he suggests, provides corroboration of his allegation that Mr. New has groomed and abused girl. They were scheduled to attend the hearing, but Mr. Foster and Ms. Thorne both indicated they did not seek to challenge the evidence on the basis, they suggested, it added nothing to the evidence in respect of the allegations before the court. At the conclusion of his evidence in the witness box, Mr. Father announced he wished to call 2 further witnesses whose evidence would be directly relevant to Ms. Mother's Allegation 10. I gave him permission to do so on the basis that he submitted statements of their evidence in advance. 2 very brief handwritten statements in the same hand and, mutatis mutandis, in exactly the same terms were subsequently produced. They were technically compliant with my requirement, if largely uninformative as to the evidence which each might give. Ms. Martin and Mr. Perry then gave evidence in support of Mr. Father. I have also seen a significant volume of social services and police evidence. I have had concerns about the functioning of this family from my earliest involvement. I have ordered 2 reports from the social services under S.37 Children Act 1989. The first was prepared by CMs, D1, at the end of 2018, the second by AK, D81, in November 2019. Further, LK, an Essex CC social worker, has produced AS.7 Children Act 1989 report, D33, on 5 March 2019, and an addendum, D45, on March 26, 2019. Dr. H.W., the psychologist appointed by the court on the application of the children's guardian, has produced 2 reports. The first on April 15, 2020, D101, and the second, following the eventual delivery up of part of Mr. Father's medical records on May 26, 2020, D131. There have been 2 children's guardians appointed to represent the children's interests. The matter came before DJ Molyneux on March 5, 2019, when she made an order that the children be joined as parties. Ms. CB was assigned by CAFCAS to the task. Ms. B made an application on April 12, 2019, B75, for a psychologist to report on the whole family. Dr. New was appointed initially, but he was unable to take on the work, and he was replaced in July 2019 by Drive LS B112. The case was listed in October 2019 for 3 days for the fact-finding, but Ms. Mother, by this time well advanced in her pregnancy with boy 3, was unwell, and the hearing had to be adjourned to the dates in June 2020. The matter came back before me on December 6, 2019 with, among other things, the news that Dr. LS was withdrawing from participating as instructed. The doctor had, I was told, become highly alarmed by what was described as intimidating communications from Mr. Father which the doctor felt were intended to influence the report, which was under preparation. The doctor was so alarmed, I was told, that consideration had been given to seeking an injunction against Mr. Father to prevent any further such behavior, and the doctor felt compelled in the circumstances to withdraw the acceptance of the instruction. Mr. Father's explanation was he had simply, and politely, contacted the doctor's office to inquire about the delay in progressing the report and making appointments. He could give no explanation as to why the doctor had taken such fright. He could not have been responsible save in the context of a misunderstanding. I had to confess that I had never, in my years of practice, or on the bench, come across a similar situation. Dr. H.W. was recruited to replace Dr. L.S., and he has reported as set out above. In the meantime, as a result of Mr. Father taking the view he could not communicate at all with Ms. Barkley because of her potential role as a witness in some criminal proceedings in which he was involved, communication between Mr. Father and Ms. B broke down. Ms. B, I understand, had not shared Mr. Father's view as to her disqualification from performing her role in these proceedings. Mr. Father was, however, adamant for a time. Ms. Barkley was scheduled to end her time with CAFCAS, and in February 2020 was replaced by Ms. R.W. as the children's guardian. It is of note that both children's guardians have at times expressed concern each was being hindered in her access to girl. Mr. Father has always disputed the severity of the problem, and suggested girl has had little or no trust in, or desire to see, her guardians. He has disputed playing any role in her reluctance or unavailability. Nonetheless, I have felt it appropriate on occasions to remind Mr. Father, in his role as the responsible parent of a December 13, 14-year-old child, he is under an obligation to ensure the children's guardian's access on the latter's terms, not his. Mr. Father has expressed the view that all the social workers who have been involved with the family, save one, Sue Powell, who has not been involved by anyone in these proceedings, have been negligent, incompetent, or biased against him to a lesser or greater extent. Lies have been told or repeated, his own views and the children's words and attitudes often misrepresented, and the conclusions reached, when unfavorable to him, prejudiced and unprofessional. He maintains both the children's guardians have been similarly deficient in the performance of their functions, and also biased against him. Dr. H.W. has produced a first report, which is unfair, unprofessional, and biased, clearly written by him on instructions, so Mr. Father says, from the children's guardian and her solicitor for whom Dr. H.W. does a lot of work, so Mr. Father says. The doctor has, Mr. Father suggests, abdicated all adherence to his professional obligations and his duty to the court in the interests of ensuring he receives further lucrative instructions, the implication being, of course, that Dr. H.W. has put his signature to a report, which contains matters prejudicial to Mr. Father, which he has been instructed to put in his report by Ms. R.W. and or her solicitor, and which he does not believe to be true. Dr. H.W.'s second report had to be produced after the first as a result of the significant delay in the production of Mr. Father's medical records. Their production was ordered, without apparent objection from Mr. Father, in the middle of 2019, along with girls. Girls have never been produced because the GP has been told by girl she does not want them released, and the GP takes the view she is competent to make that decision. Mr. Father has maintained all along he has played no part whatsoever in this decision-making process. It was entirely girl's unaided decision. Mr. Father's own records were finally produced this year, but missing a considerable portion of his early years, for which Mr. Father has no explanation, but accepts no responsibility. Mr. Father insisted the children's guardians team should not have sight of the records before they went to the expert, and so they were delivered for onward transmission in a sealed package. Dr. H.W. subsequently produced a report in which he quotes fairly extensively from the records, including some entries of relevance to the matters in issue here. They are not helpful to Mr. Father's case, as to his generally equable placid demeanor, and his role throughout the relationship with Ms. Mother as more sinned against than sinning. Mr. Father has been a boxer and latterly involved in training others, I think. He is currently a parish counselor, but has no full-time occupation, as far as I am aware. He has throughout the proceedings maintained he is the real victim of Ms. Mother's violence and controlling behavior, and whilst he does stand his ground, and can be tenacious, he is ultimately a kind person, never gratuitously aggressive or abusive. Initially he was only interested, following the breakup, in having an amicable relationship for the sake of the children, until girl made her disclosure. Subsequently, he has only been robust in promoting his children's interests and his responsibilities as their father. Ms. Mother, by contrast, he suggests, has sought to use the courts against him, making a series of malicious false allegations based on exaggerations and lies. Insofar as the extracts from his records quoted by Dr. H.W. paint a different picture, they have been misrecorded or fabricated either by the relevant GPs or by Dr. H.W. himself. In his closing submissions, Mr. Father voiced his opinion that all those involved in these proceedings, including this judge, are and have been biased against him, presenting a picture of him, which is untrue, fabricated, or exaggerated, and are as a result complicit in exposing his children to the predatory attentions of Mr. New. Mr. Father accepts he has been involved in extensive campaigning on the internet primarily. He suggests this has made him enemies, and resulted in him being targeted by internet trolls. He denies he has ever abused illicit narcotics, suggesting that is Ms. Mother's practice with Mr. New, who also abuses drugs, and has failed to pay his dealers, resulting in problems for him and the family. Ms. Mother maintains she has been the victim of Mr. Father's abusive and controlling behavior throughout their relationship. She suggests he is a man who rejects authority and will seek to evade responsibility both for his own actions and the family's responsibilities, bills, etc., by aggressive argument and intimidation. He is, she suggests, capable of being extremely foul-mouthed, even in the presence of the children, bears grudges, and takes offense, visiting retribution as he sees fit, including the threat and occasionally the use of violence against others. Ms. Mother maintains Mr. Father has always sought to control their lives, albeit through her, for example, controlling their finances, but using her name and her bank account and ensuring her compliance through his aggressive intimidation. She does not allege he has ever been physically violent to her. Mr. Father has been very active on the internet, she suggests, conducting various campaigns. Of particular relevance to these proceedings, he has been active in tracking down and exposing alleged pedophiles, and has been extensively involved in a campaign to challenge bailiffs' operations, beat the bailiffs, and advising others when dealing with bailiffs. This latter included, it seems, an appearance on a television program dealing with the issues to which he took the children. Mr. Father, she suggests, both uses and sells illicit drugs. Whilst there is some evidence from third parties with a direct bearing on the issues and allegations, and some with less direct relevance, much turns on the credibility of the main protagonists, Ms. Mother and Mr. Father. I am mindful that Ms. Mother has had the benefit of experienced and skillful representation, and Mr. Father has represented himself throughout these proceedings. Mr. Father has adopted a fairly combative style, which at one level, given his allegations and his assessment of the bias against him, might be regarded as explicable, even laudable. I take into account the possible relevance of the very human inclination, with the benefit of hindsight, to underplay one's own role in episodes, which might be objectively viewed as embarrassing or shameful, and also to exaggerate the part played by others, particularly those on the other side in litigation. Having listened carefully to, and observed closely, both these parents throughout this litigation, and taken into account the evidence given by and in support of each, I have come to a clear view about the credibility and character of each, and the role which each has played in the course of their relationship, and the fallout from its breakup. Ms. Mother, I conclude, is acutely embarrassed, and to some extent ashamed, by the history of the relationship. She has, perhaps unsurprisingly, downplayed her own part in some of the problems which arose, and some of the incidents which have been the subject of this examination. Whilst I am entirely satisfied where the dominance and power lay as between these two parties, I am also satisfied the evidence shows on occasions she has shown she is able to defend herself somewhat more assertively than she has accepted, at least in the evidence which has been put before me. I make it plain there is no criticism of her implied in this. She would have had every right to defend herself, and even fight her corner. I am, however, quite satisfied the evidence does not support the conclusion she was in any meaningful sense the aggressor in any altercations which occurred between these parties. I am quite satisfied Mr. Father would not have tolerated it had she attempted it. Ms. Mother struck me as a witness generally trying to do her best to present an accurate picture of the parties' relationship and the incidents described. I did not find her to exaggerate, albeit she may have sought to downplay her role at times, whether out of shame or embarrassment. I did not get the impression she was other than a truthful witness, broadly speaking. She has not alleged that Mr. Father was ever physically violent to her, when, had she wished to embellish or exaggerate, she might easily have done so. Given the rest of the evidence, such an allegation might well have carried some credibility. She has accepted she is not able to prove certain of her allegations to the relevant standard, without resiling from them. Ms. Mother's evidence is, of course, given against the background of allegations of bullying and control by Mr. Father over many years in the relationship, and, subsequently, her belief that she, Mr. New and her family have been subjected to a baseless, spiteful, and vindictive campaign by Mr. Father designed to cause them maximum harm. The atmosphere between these parties is bitter and extremely hostile, and that too is a feature of her evidence. Mr. Father, as I have said, presents himself as much more the victim of Ms. Mother's behaviors than the other way around. He maintains that any suggestion he is aggressive or controlling is completely untrue. He is a basically kind man, slow to anger, sometimes tenacious, but never abusive or aggressive. Mr. Father suggests he is much misunderstood, and is guilty of nothing more than protecting his children, and standing up for himself. This is certainly not a picture which I find is supported by the evidence. Mr. Father makes frequent attempts to present a superficially charming persona. However, I am satisfied on the evidence he is in reality a manipulative bully, and this temporary and highly fragile attempt at charm is one of the methods which he employs to achieve his aims. It is of note that Dr. H.W. makes the following observation at para 128 of his first report, D129. The father, although charming, wants things his way. As a small example, he would insist on me calling him father, instead of Mr. Father. I think that this is an attempt at making our relationship equal when it is not, but my concern was his consistency, and his inability to accept that perhaps I might want to refer to him differently. I accept that Mr. Father challenges the doctor's evidence, and has not yet had the opportunity to cross-examine Dr. H.W., but this is an example of the doctor's perception, which accords very firmly with mine. This is a gambit employed by Mr. Father frequently, even in the courtroom. It is also instructive that, having failed to persuade Dr. H.W. to his cause, he has now gone very firmly onto the attack, accusing the doctor, and the children's guardian, and her solicitor, of a course of conduct which would not only end their professional careers, but would almost certainly result in criminal charges. All this is based upon the otherwise unelaborated motivation that they have, without apparent personal advantage, and at considerable personal risk, conspired to do him harm. It is not only not credible, it is incredible. There are other examples in the evidence. When Mr. Father is crossed or does not get, or is deprived of, what he wants, he responds aggressively, and has shown himself quite capable of deploying the most egregious of allegations on the flimsiest of evidence against those who have crossed him. In Dr. H.W.'s second report, he quotes extensively from the partial medical records which Mr. Father finally supplied. As I have said, there is currently no explanation why the records are not complete. Mr. Father denies the accuracy of the records as quoted, however. It must be remembered Mr. Father refused to allow anyone but Dr. H.W. to have sight of the records which he obtained, and so Mr. Father is the only other person involved who has access to the records themselves. The report was filed and served a week before the hearing, and at no stage did Mr. Father seek to demonstrate from the document that his allegations as to the inaccuracy of Dr. H.W.'s report are correct. I am satisfied, on the balance of probabilities, that the records are accurately reported. From Mr. Father's medical records the following matters appear, D136FF. In 1995 he was diagnosed with PTSD. In June 2009 he was depressed, and by December the same year he was described as being under the care of the mental health team, consequent upon which a psychiatrist described him as having traits of paranoid personality disorder, sensitivity to insults and setbacks, tendency to bear grudges with refusal to forgive along with a combative and tenacious sense of personal rights. In 2010 and 2011 he was again feeling depressed, and was once again referred to the mental health team. In August 2011 he is described as being extremely preoccupied with ideas of revenge against people he may think have caused some harm or injustice to him. Father describes himself as being suspicious, not trusting people, extremely vindictive, very sensitive to comments and setbacks, and with an extreme sense of pursuing personal justice, and bearing grudges, and being preoccupied with paying back people for things that may have happened years ago, going on for a long time. However, he feels things are getting worse lately. Father is currently seeking help as he feels this is not helpful, and it impacts on his relationship with his partner, Ms. Mother, as well as other people. Mr. Father received the likely diagnosis of paranoid personality disorder and dissocial personality disorder. An organic cause for paranoid personality disorder was subsequently excluded. In November 2011 he is reported as having made an aggressive phone call re-needle change. Has asked my name to make a complaint. It is not clear what the needle change was for, but Mr. Father a diabetic. In January 2013 it is shown he failed to attend psychiatric appointments. In June 2013 there is a record of a letter from the CEO of the NHS Trust, which alleges Mr. Father had left the GP's secretary intimidated and uncomfortable after a telephone call. Mr. Father disputed this at the time. In January 2014, he walked out very aggressively when an attempt was made to admit him. Wife, very worried. In April 2014 he was very stressed about impending eviction, feels if he sees the landlord, and he starts to take things out he will kill him. Never felt so bad before. On September 25, 2018, multiple problems, stress marital relationship breakdown after 15 years, concern over possible accusation of abuse of daughter by his partner's new boyfriend. On September 28, 2018, there was a further referral to the mental health team, and on October 18 he was recorded as having severe symptoms of depression and anxiety. On September 25, 2019, he is recorded as going through a lot of stress at present. In February 2020, feeling stressed about many things in life. In his evidence, an attempt was made to explore these entries with him. He denied they painted an accurate picture, and did not accept he had been referred to the mental health services. If I go to the GP and report something, that does not amount to a diagnosis of a disorder. The reports, he maintained, were at best exaggerated. In his submissions, as I have said, he alleged they were largely misrecorded, or actually falsified by Dr. H.W. In his conversations with the social worker for the preparation of the first S.37 report, D13, he described himself as having no mental health issues, a statement which was at the very best highly misleading, if not a deliberate untruth. I'm not clear what part illicit narcotics have played. Mr. Father suggests both Mr. New and Ms. Mother have serious drug habits, and Mr. New and Ms. Mother deal drugs, Mr. New even to school children. In turn, Ms. Mother suggests Mr. Father has used and dealt drugs extensively through the relationship. Mr. New denies having an issue with drugs, albeit he accepts he once had a bit of a problem with alcohol and attended open road to get a grip on it. Ms. Mother accepts she has taken drugs in the past and has been arrested for supplying them in the past, D11. She denies use since the children arrived and has had a test in these proceedings, D75, which demonstrates no evidence of cocaine consumption between January and July 2019. Mr. Father has failed to provide the drug test, which was commissioned much earlier in the proceedings. He failed to provide a sufficient hair sample from any part of his body, and, more recently, did not provide a fingernail sample sufficient for the test. None of this Mr. Father accepts was his fault. There is some suggestion in the social work evidence he has had a clear test, but the documentary evidence of the testing to support that is not in the papers. Mr. Father has produced a statement from S.J. C94, in which she alleges Mr. New gave her cocaine in a pub. It is not clear how old she was at the time, although I suppose one may assume something from the suggestion the exchange took place in a pub. She does not say how she knew it was cocaine, only that she realized it was after it had been given to her. She does not suggest Mr. New told her it was cocaine, nor that he was selling it to her. Mr. New denies the incident. Ms. J's sister, K.R., reports the same allegation, but it is clear she was not a first-hand witness to the incident. None of the three witnesses put forward by Mr. Father suggests in her statement that Mr. New was a notorious user or dealer. Other than Mr. Father's reports, there does not seem to be any police evidence in support of the allegations against either Ms. Mother or Mr. New. Ms. Mother does not include in her schedule an allegation in relation to Mr. Father's drug use or dealing. Mr. Father, however, does include the allegation against her. He bases his allegation upon her own admission to the social worker, D11. Otherwise, there is nothing more than his unsupported allegation that she was a regular user and dealer, and frequently incapable through drink. Mr. Father denies using or dealing drugs. The Essex police evidence, D20, is that Mr. Father is the subject of a long history of reports of domestic abuse, drug dealing, and drug abuse. When that report was prepared, at the end of 2018, there had been 32 police intelligence reports and 35 police investigations and reports. Mr. Father is known to other police forces across the country, and records involve domestic violence, harassment, and malicious communications. In November 2017, Mr. Father was involved with an internet group chat and made threats to kill towards another individual and encouraged the victim to commit suicide. The victim received 1,500 emails, and Mr. Father was very abusive. The report further records Mr. Father was arrested for possession of drugs, weapons, and threatening behavior. He was dealing drugs from the family property and had possession of a baseball bat. Mr. Father has also had altercations with the police and threatened to stab a police officer. The social worker, whom Mr. Father also dismisses as incompetent and biased, concludes this passage. During meetings with Mr. Father, he has expressed these police reports to be false and states he has never been convicted of anything. Mr. Father maintains that all the evidence is false, and he has expressed he would like copies of all records. When I asked him about this information, however, he accepted these reports etc. did relate to him, albeit he asserted they were all based upon malicious and false information provided to the police and denies any of it is true. He accepts he has been convicted once for an offense of ABH, but says he has no other convictions, and I have seen no evidence to contradict that assertion. Mr. Father does not suggest any of these allegations, all of which clearly predate the breakdown of the parties' relationship, was made by either Ms. Mother or Mr. New. It is, as I have indicated, a consistent theme of Mr. Father's evidence that he is the comparatively innocent victim of malicious and false allegations on all sides. The volume of these allegations is substantial, and they cover a very long period, effectively from the beginning of the records available up to date. There is no explanation from Mr. Father as to why in the past all these people, including police officers, social workers, solicitors and doctors, should have taken it upon themselves, individually or collectively, to lie about or exaggerate these allegations against him. Since his separation from Ms. Mother, however, he has satisfied himself that she and/or Mr. New are the direct or indirect authors of all the continuing false and malicious reports against him. Their motivation has been to distract from their affair, which he interestingly describes as disloyalty, C-113, and to secure the return of girl to their household so Mr. New may continue his abuse. It is revenge for not allowing girl to live in an environment where she is at risk of sexual assault and abuse. In the early hours of January 4, 2020, the police were called to the hotel where girl and Mr. Father shared accommodation. An anonymous neighbor had reported concerns that girl was being abused. There was much shouting by Mr. Father alleged. The police were so concerned by what they found they removed girl under a PPO. It is correct, when subsequently questioned about it, girl denied the alleged abuse and seemed comparatively unconcerned. It is difficult to know what impact girl's more recent lived experience may have had on her, but it is clear she did not provide any support for this allegation when subsequently questioned. Nonetheless, PC Hillier Records, E203, on arrival Mr. Father was uncooperative from the start and aggressive towards female officers. The report confirms a discussion with the anonymous informer on the scene in which she added she had seen girl crying outside their accommodation on New Year's Eve, saying her dad had thrown a plate at her. Mr. Father initially suggested this report had in fact been made directly by Ms. Mother, falsely and maliciously. When it was pointed out that the police spoke to the informant at the scene, Ms. Mother clearly not being present, he suggested he was aware the person concerned was in fact a close associate of Ms. Mother and had been put up to making the allegation by her. The report goes on to suggest that, in the officer's assessment, girl appeared frightened, but pretending to be okay, and was not shocked to see the police or reluctant to go with them, despite Mr. Father telling her she would be put in a cell. Based upon the allegations, Mr. Father's aggressive behavior, and girl's behavior, the officers removed her under a PPO. Mr. Father's version is that nothing untoward had happened. They were in fact in bed when the police arrived, and, whilst he was annoyed, he was not aggressive. The informant had been put up to it by Ms. Mother, and the police officer was lying about the rest of it. The medical record entries paint a picture which I am quite satisfied is accurate, reflected, as it is, by a wealth of other evidence. The incident with Mr. Kemp, the process server, must have been shocking and frightening for all those present, including girl. I shall deal with it in greater detail below, but I am entirely satisfied Mr. Father is not being truthful in his version of those events. Provoked only by Mr. Kemp delivering court papers to Mr. Father, he behaved extremely aggressively, and was so abusive and foul-mouthed in his treatment of him that Mr. Kemp felt compelled to inform the solicitors he would not accept instructions to have dealings with Mr. Father again. I was impressed with Mr. Kemp, a mild-mannered and unintimidating man, but one with very considerable experience in his job. In the tens of thousands of serves in which he had been involved, he had only ever disqualified himself from further involvement with a subject on about 20 occasions, mainly when he had been physically attacked. Mr. Father gave a very different version of events, which I unhesitatingly reject, and suggested Mr. Kemp must be a snowflake to have reacted as he suggests. In general, I'm afraid I found Mr. Father to be a thoroughly unreliable witness, and I have found it difficult to accept his evidence on any issue under examination in the absence of corroboration. He suggests Ms. Mother is in denial of her problems, and the threat posed by Mr. New. I shall return to the evidence against Mr. New. However, I am quite satisfied it is Mr. Father who is in denial of his problems, or worse is actively concealing them. Where the evidence is a simple choice between Ms. Mother's version and Mr. Father's, I have little hesitation in preferring Ms. Mother. I am satisfied Mr. Father was sufficiently offensive when contacting the office of Dr. L.S. as to spook the doctor into withdrawing from the case. I reject Mr. Father's suggestion. He was politely requesting information as to when the appointments would be arranged. Given my assessment of Mr. Father's personality, based upon the evidence, I have no difficulty accepting he would have been quite capable of being gratuitously offensive and intimidating. His motivation is unknown. His mental health issues may have played a part, but it is clear the doctor formed the view that Mr. Father was attempting to influence the conclusions of the report. There is no suggestion the doctor was other than averagely robust, and it is not credible, in the circumstances, to suggest this conclusion was arrived at on the basis of a misunderstanding. Ms. Mother gives many examples of his aggressive and controlling behavior. In 2008, when boy 1 was a tiny baby, C31, Mr. Father got into an altercation with a man in a pub when she and the children were present. She describes him getting into a heated argument during which he lost his temper, all the while holding the 2-year-old girl. He then handed girl to a family member before punching the man to the jaw, knocking him out. Girl, she says, was witness to it all. Mr. Father accepts an incident of the kind did occur, but says it has been highly exaggerated by Ms. Mother. It was not as dramatic as she suggests, and he only acted in self-defense. I have little hesitation in accepting Ms. Mother's version of events. In 2015, Ms. Mother describes, C32, an incident at their home when the police had to accompany the operatives from EDF to gain entry to change the meter. It seems it had proved necessary for a court order to be obtained to install a prepaid meter. Mr. Father, she says, refused to allow them entry, and there was much aggressive and abusive argument outside the house with Ms. Mother and girl inside, both frightened and embarrassed. This, she suggests, falls into the pattern Mr. Father has of challenging authority whenever possible, and refusing to pay the family's bills if he can get away with it. Eventually, entry was forced because Mr. Father refused to open the door for them. The door was, and remained in 2018, damaged. Mr. Father suggests this was all in fact Ms. Mother's doing. She it was who wanted to challenge the bills, which were in her name, and she had authorized him to negotiate on her behalf. Part of the problem, he maintains, was that she frittered away on luxuries. Money which he gave her to pay the bills. There is no external evidence of any of this, but they both agree an incident of the kind did occur. Given my understanding of the personalities and the dynamics of the relationship, it is simply not credible that Mr. Father was playing the role of some sort of honest broker at the behest of his spendthrift partner. It is much more in keeping with my assessment of him that Mr. Father would have been as obstructive and belligerent as possible, particularly if, as Ms. Mother suggests, and I accept, he was filming the whole event for publication on the internet. Once again, I accept Ms. Mother's version of this event, and note Mr. Father was insensitive to the effect on innocent bystanders, in particular his own child. In February 2018, C33, Ms. Mother records an incident at the Blackwater Medical Center, where the children are registered, when Mr. Father was aggressive and abusive towards the staff, as a result of which the staff called the police. CMs, in preparing the first S.37 report, records having seen the letter confirming this, D26. Girl was present as it was she who needed medical attention. Mr. Father suggests this is a complete misrepresentation of the situation, in which he was simply attempting to ensure his daughter was seen, and the reason the police were called was because he was filming the incident, for unexplained reasons, and the staff wanted him to stop. He was neither abusive nor aggressive. Reports that he was are untrue. This incident has echoes from so many others, in particular that mentioned at para 35F above. I have little doubt that Mr. Father was, typically, both aggressive and abusive. CMSS.37 report, D1, did not meet with Mr. Father's approval. He told me he did not get on with the social worker. He felt she might be related to Ms. Mother. At para 6.12, D6, Ms. CM's records that, when discussing concerns about Mr. Father sharing a bed with his 11-year-old daughter, Mr. Father became quite angry and expressed he was allowed to sleep in bed with his daughter if he wanted to, and if this was what she wanted there should not be an issue. Mr. Father disputed he had become angry. At D16, she records he had prevented sessions of key direct work proposed by the social worker with girl. until a court order was obtained requiring him to afford access. Mr. Father's explanation was that the caravan in which they were living at the time had a poor mobile signal, and anyway he did not get on with the social worker. In respect of the report at D17, that he had been questioning Boy 1 and Boy 2 at contact about which parent they would prefer to live with, his explanation was that he would not have avoided the topic. At D18, Ms. CM's reports, during conversations with Mr. Father he has gone from talking calmly and rationally to becoming aggressive and shouting, or at least passive-aggressive and controlling. Mr. Father tends to react in this way when he has been challenged or does not like the response given to a statement or question he has made. She goes on to give an example of this behavior surrounding Mr. Father's refusal to allow girl to participate in a planned session of direct work. Mr. Father is reported as saying he would not allow the local authority access to his daughter unless the police were present, and that any meeting with girl should be recorded. He became irate when denied and left. Mr. Father accepts he insisted any meeting with girl should be recorded, but denied he knew there was a plan for work with girl on that occasion. He accepts it did not take place. Also on D18, the social worker records a number of occasions when the social worker has terminated calls to avoid distress to girl, because Mr. Father has become irate with girl clearly present. Mr. Father's response to the suggestion the discussion should not take place with girl present was to say he shares everything with girl. Mr. Father told me that he keeps his daughter informed and is subtle in what he says to her. The social worker, apparently, used this as an excuse a couple of times to get out of a call. He did not explain why she should have wanted to do so. At D19, Ms. CM's records Mr. Father told her he had a video which he had taken of Boy 1 visibly traumatized having been left alone at home by Ms. Mother to care for 2 younger children. Mr. Father suggested the children had been abandoned. Having viewed the video, the social worker was clear that Boy 1 was not distressed as he was questioned by Mr. Father. The incident involved Ms. Mother going next door for a short time, and the children knew where she was. At D25, she recounts an incident at the end of an observed session of contact when Boy 1 was prompted by his father to tell the social worker something. Boy 1 appeared confused and looked at his dad before looking at me, and then asked his father what he meant. Mr. Father then prompted Boy 1 to talk about how he really feels. Boy 1 then looked to his father confused still and asked him, "What did you want me to say again?" The social worker described the exchange as extremely inappropriate. Mr. Father told me the report was almost accurate. I am quite satisfied, on the evidence, Mr. Father's suggestion that all the negative evidence against him is fabricated and or deliberately exaggerated by the professionals, unidentified persons who wish him ill and lay associates of Ms. Mother and or Mr. New, is nonsense. I suspect he knows and understands his case to be nonsense and hopes, in some improbably ambitious way, to persuade me he is no more than the kind, if stern and tenacious, person he suggests. The alternative possibility, which in a sense may be even more troubling, is he has convinced himself his position is correct and he is genuinely the victim of a huge conspiracy, or series of conspiracies, and random acts of unprovoked malice. I am not, of course, qualified to make any sort of medical diagnosis, but in the circumstances it comes as no surprise to me that his medical records contain references to paranoia. The evidence overwhelmingly demonstrates Mr. Father's highly volatile temperament, and the aggressive, often highly offensive, tactics he deploys to deal with anyone who opposes or challenges him. His attempts to portray himself as comparatively non-confrontational, mild-mannered, and kind are clearly either delusional or deliberately deceptive. It seems, particularly when dealing with the establishment, his preferred MO is to be confrontational and oppositional, often under the guise of insisting on his, or his children's, rights. Mr. Father is capable of attempting to be charming, but the evidence demonstrates this is a relatively fragile veneer, which does not often survive any perception that those with whom he is dealing are not, or are no longer, on his side. He is obviously capable of being agreeable, as his children attest by their continuing expressions of affection and desire to be in his company. Further analysis will be needed of the level of dysfunctionality of these relationships. It may well be the case they have learned, or will learn, the consequences of confrontation with him, and make sure to avoid it. It is not yet entirely clear to me what the children's lived experiences of their father have been. It is, however, clear he is not able, or chooses not, to control his behavior simply because the children are witnesses. It is also clear he sees nothing at all amiss with close involvement of the children in the pursuit of his agenda, and their persuasion and recruitment to his cause when necessary. The concern expressed by CMs, D29, that Mr. Father is unable to moderate his own emotions and responses, and as a result reacts to situations with anger and aggression regardless if his children are present or not, is one which has considerable empirical support. I will now turn to consider the schedules of allegations, commencing with Ms. Mother's. Ms. Mother's allegations. Allegation 1 is that Mr. Father was aggressive, controlling, and manipulative towards her throughout their relationship. Ms. Mother describes the family dynamic as his way or no way, C30. She describes many ways in which she alleges he was manipulative or controlling, and at para 26 of her statement, C33, describes his controlling behavior when she attempted to separate from him on an earlier occasion. Ms. Mother, as I have said, does not allege actual physical violence against her. Mr. Father maintains this is a reverse of the true picture. It was in fact Ms. Mother who was the aggressive, indeed violent, and controlling partner. Mr. Father alleges Ms. Mother was often unavailable to the children, through absence, alcohol or drugs, and it was he who kept the ship afloat and protected the children from their mother's neglect. Mr. Father suggests Ms. Mother has entirely fabricated these allegations to justify her disloyalty and deflect from new news sexual assault and grooming of my daughter, C113. He says Ms. Mother's violence towards him was witnessed, but has not sought to adduce any witness evidence to support this claim. He does suggest girl witnessed her mother's violence towards him, but, despite many opportunities to make that allegation to numerous social workers, police officers and children's guardians, I can find no record of girl herself confirming this. Mr. Father prays in aid of his version that Ms. Mother proposed marriage to him after 14 years together. Ms. Mother has neither offered, nor been asked for, confirmation and or explanation of this. There is no corroboration for Mr. Father's version, and there is ample corroboration of the character traits described by Ms. Mother. Given my understanding of Mr. Father based upon the evidence I have seen and read, I am quite satisfied Ms. Mother's portrayal is much the more likely to be correct. Mr. Father has demonstrated often that he finds it almost impossible to tolerate dissent. I do not find it remotely credible he would have meekly accepted the role of subordinate in their relationship, or tolerated for even a short time the behavior which he attributes to Ms. Mother. I accept there were probably occasions when the arguments may not have been as one-sided as Ms. Mother implies. Girl states that both her parents could be shouty, D53. However, the ability of Ms. Mother occasionally to stand her ground does not dissuade me from the conclusion that her characterization of the dynamics of their relationship is much more likely on the balance of probabilities to be accurate. Allegation 2 is that Mr. Father was, throughout the relationship, financially controlling, and caused Ms. Mother to get into debt. She alleges he refused to have a bank account in his name, and used hers for the family's operation. Ms. Mother says he often did not pay the rent, and would not let her pay some bills, saying he would deal with any bailiffs. He insisted on dealing with any creditors. Mr. Father maintains Ms. Mother was squandering her money on luxuries, while he was left to pay for the family's day-to-day expenditure. It was he who ensured the rent and bills were paid. When they fell into rent arrears, it was because she spent the money he gave her for the rent on luxuries when her benefits ran out. She was, he alleges, fraudulently claiming benefits more or less throughout their relationship, and using them for her own expenditure on frivolous purchases such as Go Fresh boxes, pizzas, expensive clothes and shoes, and massages for an imaginary back condition, C114. He had to accept in evidence, if his allegations of this history of criminality was correct, he was at the least a passive accomplice and benefited, directly and indirectly, from the proceeds. Ms. Mother, he suggests, has fraudulently claimed legal aid. housing benefit, and Social Security benefits. She is a consummate liar and fraudster. Ms. Mother denies these allegations in the main, accepting that the Go Fresh boxes were ingredients purchased to facilitate girls' homeschooling, and that the massages were sessions with an osteopath in respect of a far from imaginary back condition. Despite ample opportunity to do so, in fact neither party has provided much if any evidential flesh to put on these allegation bones. I have not been shown sufficient evidence to conclude who was responsible for the rent and whether or not it was paid, who was claiming benefits, whether licitly or illicitly, and for what the money was used, who had what by way of income, and whether the other household bills were paid or not. I am, however, satisfied Mr. Father's suggestion. He once again meekly put up with the behavior, which he describes over years of cohabitation, is highly unlikely. Given my conclusions as to the family dynamics, I am satisfied Mr. Father was more likely to exert control over the family finances, and, if he thought they could get away with not paying a bill, Ms. Mother would certainly not be permitted to dissent. Allegation 3 is that Mr. Father is aggressive and verbally abusive towards others when the children are witnesses. Mr. Father's response is never, provide proof. There is certainly proof of this behavior when girl was a witness. The evidence of Mr. Kemp, which I shall deal with as allegation 11, gives a very stark and shocking example. Ms. CMs has described terminating calls because she was concerned at Mr. Father's behavior when girl was present. I accept Mr. Father behaved aggressively and abusively with girl as a witness during the incident when EDF forced entry to the home, refusing to allow Ms. Mother to defuse the situation and filming the scene for publication on the internet. He clearly behaved aggressively and abusively at the surgery with girl present when the police were called, and when the police called at the hotel and took girl into police protection. I would be very surprised if these were the only incidents witnessed by any of the children. There is certainly evidence to support the conclusion that girl has become inured to this sort of behavior. I don't think there is any third-party evidence of the boys being exposed to this sort of behavior, but, given Mr. Father's amply demonstrated lack of inhibition, I accept Ms. Mother's evidence, and would find it surprising if it were not so. Allegation 4 is that Mr. Father has been verbally abusive towards the children. In fact, what is suggested in the evidence, C33, is that he swears liberally in front of the children, both in conversation with others and with the children themselves. It is suggested he encourages the children to follow his contempt for authority. Whilst I accept, given all I have already found to be proven, the description of the behaviors is more likely than not to be accurate, I do not find this supports an allegation Mr. Father has been abusive towards the children. I accept Ms. Mother's evidence that the children have been disciplined at school for repeating offensive words and gestures. Allegation 5 is that Mr. Father threatened to kill Ms. Mother and Mr. New on August 29, 2018. Her evidence, C35, is that, following the recent breakdown of their relationship, Mr. Father called to say he was coming and attended at her property. It transpired he had with him the recent recording of girl, which he alleges is evidence of sexual assault on girl by New. It is accepted a neighbor, XX, was a witness to whatever occurred. Ms. XX and Ms. Mother are recorded making the report to the police by telephone at 14.24, E43. Ms. XX gave a statement to the police, E13, as did another unnamed witness, E24. It is alleged by Ms. Mother that she was called out of her house by Mr. Father to find him in his car with Maddie, and the recording was played to them. Mr. Father was extremely irate, she suggests, and threatened to kill her and Mr. New. Ms. Mother gave a statement to the police on the day, E5, which accords with the evidence she has given in these proceedings. Mr. New gave a witness statement to the police, E15, in which he reported Mr. Father had come to his house and threatened him a few days earlier, and XX called him shortly after this alleged incident to warn him that Mr. Father had threatened to kill him. The police were involved, and the matter did not result in a prosecution, but a restraining order was put in place against Mr. Father. There was a CCTV video of the incident, apparently from Ms. XX's equipment, which was a feature of the evidence against Mr. Father at the time. Ms. XX was on the list of witnesses to be called by Ms. Mother but did not attend this hearing, Ms. Mother alleges, because she has been intimidated by Mr. Father. Mr. New did give evidence, but was not questioned about his above evidence by Mr. Father, and, of course, he could not give direct evidence of the alleged threats. Mr. Father told me in the witness box the allegation is a fabrication. He accepts he was upset after girl's disclosure, and went to Ms. Mother's house to bring it to her attention. He denies he was abusive or threatening as suggested. He denies intimidating Ms. XX, or the other witness, and suggests they have failed to appear because they have lied to support Ms. Mother. I have not seen the CCTV video. Mr. Father alleges the criminal case was discontinued because the video evidence was found to have been tampered with, although Ms. Mother denies this, and I have nothing other than Mr. Father's evidence to me. It is not mentioned in his statement to support this suggestion. He was made the subject of a restraining order as a consequence. Given all I have already concluded, I am satisfied on the balance of probabilities Ms. Mother's evidence is accurate. I acknowledge Mr. Father has not been able to cross-examine the other witnesses, but he did have the opportunity to question Ms. Mother and Mr. New. Other than that they are all in it together, he has offered no explanation why the other witnesses should have opened themselves to a charge of perjury by making the statements they did. Given the short time between the incident and the police attending to question the witnesses, as a result of which statements were taken, the uniformity of the evidence of all the contemporaneous witnesses suggests one of two things: an accurate description of an incident recently witnessed, or a well-planned conspiracy. Mr. Father clearly supports the latter explanation. I do not. The motivation for this conspiracy, he suggests, was Ms. Mother and Mr. New wished to divert attention from their disloyalty and infidelity and to distract from Mr. New's crimes. However, at this point the relationship between Ms. Mother and Mr. New was public, albeit only recently so, and the allegation of sexual assault against Mr. New only made within a very short period of time before these reports were made to the police. Mr. New was not even present, and there is no suggestion he was even aware of the allegation against him at that stage. The conspiracy theory is highly improbable, and would have involved a degree of prescience that Mr. Father would attend that day, a coincidental, but perhaps less unlikely prediction that he would be in a state, a further prediction that he would make an accusation of such gravity as to justify the conspiracy, and the suborning of neighbors to perjure themselves at fairly short notice, to a uniform story, and in support of Ms. Mother's and Mr. New's nefarious agenda without any apparent, or alleged, motivation of their own. I am satisfied on the evidence he did indeed attend at Ms. Mother's property, flew into one of his familiar rages, triggered on this occasion by what he had allowed himself to believe was girl's disclosure of sexual assault, and threatened to kill them both. It is clear that even by then Mr. Father had concluded Mr. New was responsible for the breakup of his relationship. The then nascent visceral hatred for Mr. New, which has subsequently become so evident, and well evidenced, was almost certainly feeding his documented penchant for visiting revenge against those who have wronged him. I am satisfied this is an incident which took place as described by Ms. Mother, and was entirely in character. Allegation 6 is, since the parties split up, Mr. Father has harassed and intimidated Ms. Mother, her friends and family. In her evidence, Ms. Mother accepted she had little more to support this allegation than supposition about incidents which had occurred of damage to property and postings on Facebook, evidence of which she had not produced. She accepted she could not really support this allegation on the evidence which was before the court. I agree and do not find this allegation proved. Allegation 7 is that Mr. Father has frequently been seen standing just outside the zone from which was excluded by his bail conditions, or the terms of the restraining order, and shouted to the children, or watches the house. Mr. Father denies this in his written response on the schedule, A8, but in his evidence before me he accepted he had indeed been in the vicinity often, and had been careful not to breach the terms of the restrictions, staying just outside the zone. He denied his intention in positioning himself on the edge of the zone in view of the house was to watch the house, or intimidate Ms. Mother, but accepted he did so in order that he might be able to communicate with the boys who wanted to see him, and whom he loves very much. Given all the circumstances, I find it somewhat disingenuous of Mr. Father to suggest there was no desire to intimidate Ms. Mother by his presence in the circumstances which he describes. However, I accept this was not his primary intention, but perhaps a happy collateral consequence of his genuine desire to see more of his boys. He has always purported to find the restrictions placed upon his contact with the boys both inexplicable and deeply offensive. There is, moreover, no suggestion he was doing anything which was prohibited, other than, perhaps, to see, in a distant sense, more of his boys and to reassure them, and be reassured himself. On his own evidence this allegation is made out, but I am not persuaded it amounts to a significant criticism of Mr. Father, other than perhaps as an example of his often hair-splitting and legalistic approach to boundaries. Mr. Father is a man who may observe the letter of the law with little regard for the spirit unless it suits his purpose. He is, as I have said, clearly an intelligent man. Allegation 8 is that Mr. Father has isolated girl and manipulates her against her mother and others she is close to. Mr. Father's written response, A8, is that Ms. Mother has isolated herself by assaulting girl, a reference to an incident at Madison Heights which forms the third of Mr. Father's allegations. In fact, Mr. Father's case goes a little wider than that. He maintains he has exerted no influence whatsoever over girl's decisions in relation to her mother and her maternal family. The reality, he suggests, is girl is scared of coming into contact with Mr. New, her abuser, and feels betrayed by her mother who has disputed her allegation against Mr. New and has chosen him over her. She is scared of her mother as a result of this assault, and feels rejected by her maternal family, who have sided with her mother, and are angry with her for choosing to live with her father. The isolation of girl in her father's care has been a consistent concern of all the professionals involved with this case. It is one I share. It is apparent, whatever may have occurred prior to her decision not to return to her mother's care, her attitude towards contact with her mother and her maternal family has hardened significantly over the time since she has been confined in her father's care, and her narrative has become closely allied with, if not almost indistinguishable from, his. Mr. Father suggests he does nothing but give a voice to girl's own concerns and allegations. However, given how seriously he has at best misinterpreted what she has been saying, it is difficult to avoid the conclusion, at the very least, she has become very enmeshed within her father's agenda. The impression he gives, and would like to have accepted, is that she is a young woman who knows her own mind, and has made her own decisions from which he has not sought to dissuade her, because he thinks they are justified, and he supports them. It is worth remembering that girl is a child. She was 12 when all this started, and is now only 14. Her own description is that she is anxious to be out on her own, D38, D116, she is often described, including by Mr. Father, as an anxious child. Prior to the separation there were concerns expressed about the relationship between father and daughter. Concerns have been raised about Mr. Father encouraging girl to share his bed, and even his bath in circumstances, which have been described as inappropriate. Mr. Father has angrily rejected the implication of impropriety, D6, and defended the practice as the child's choice. Dr. H.W. suggests possible parallels between the relationships of both girl and her mother with Mr. Father, D123. Ms. Mother had been led to dependence upon Mr. Father until she was able to escape. Subsequently, a similar dependence has been created with girl not knowing how to step away from her father. For the past 2 years girl has been more or less constantly in the company of her father, living in often cramped conditions, a caravan, a hostel, and more recently a hotel room. For a period she was moved into the accommodation of a new girlfriend of Mr. Father, but soon had to move when they fell out. Prior to the separation, reports were made to the social services about concerns for girl who was being homeschooled, D20, and had gone from being happy and sociable to withdrawn and unhappy. She was often taken out by her father to witness or participate in his campaigning activities, and there is an allegation, I think disputed by Mr. Father, that he subjected her to the humiliation of having to carry an inflatable sex doll around at a car boot sale as some sort of punishment. It is some consolation that girl does now attend mainstream school, but there is no disputing she lives a fairly isolated existence outside school as her father's main companion, living in very close proximity to him. I am satisfied the evidence shows her decisions are significantly influenced by her father and the furtherance of his agenda. Whatever happened before she left her mother's household, the evidence shows she was subsequently open to constructive contacts with her mother and her family. I am satisfied Mr. Father is the one who has discouraged girl from enjoying good or improving relations with her maternal family. It may be he would see such as a manifestation of the disloyalty which he finds so wounding in her mother. Despite the orders of the court and the advice of the professionals, I am satisfied Mr. Father has actively discouraged the relationship between girl and her mother and maternal family. As Dr. H.W. suggests, Mr. Father shows limited insight into the effects of parental conflict on the children, D127. The evidence shows he does not hesitate to recruit the children to his agenda, and they have been indoctrinated in the rectitude of his cause. Girl, Dad is always right, D110. Boy 1, his father never tells him lies and always tells him the truth, D23. As I have already highlighted, Mr. Father is quite frank about the fact that he shares everything with girl, albeit subtly, and rejects the professional's criticism that he exposes her to inappropriate conversations and emotions, D18. It is, of course, evident she would not be given by him a choice between her mother's version and her father's. Early on in this process, CMs expressed concern that it is unclear if Mr. Father's parental presence with his children is healthy, as his authoritarian approach tends to present itself as control and power over his children, which may mean the children are responding to his cues due to feeling scared rather than out of normal parental respect. It is not clear to what extent the children might actually be scared of their father. His relationship with them all on one level is jovial and close. He is, however, adept at the mechanisms of control and, as I have concluded, I am quite satisfied they will each have experienced his behaviors, which will have reinforced in them the inadvisability, and indeed futility, of dissent. He acknowledges he would not have avoided the subject of seeking the boy's opinion concerning with which parent they would like to live, D17, without a hint of recognition of the unfairness and inappropriateness of discussing such matters with his children, nor any discernible insight into the unlikelihood of obtaining an objectively reliable answer given the confusion and conflict which the question would inevitably engender. Mr. Father sees it as unobjectionable, in what he sees as the circumstances, that he encourages, possibly even instructs, the children to call Mr. New pedo. I have very little doubt, given the opportunity, he would seek to persuade the boys to abandon their mother's home in favor of whatever he has to offer. In the early days post-breakup, and post the recording of the allegation against Mr. New, girl was amenable to having at least contact with her mother and grandmother. Had this been allowed to progress uninfluenced, there seems at least a very good chance the situation could have been substantially repaired. CMs reported, D3, conversations with the boys which confirmed Ms. Mother's report that hitherto the children had enjoyed close and positive relationships with their maternal family. It is apparent during the observed contact girl and her maternal grandmother were warm and affectionate towards each other. The social worker had no concerns about their relationship. Overall, the children have spoken fondly of the time spent with their extended family. However, when spoken to, girl said she no longer likes her grandparents or aunt as they are angry with her and on her mother's side. Her grandmother stated she has never felt any anger towards girl, expressing she is loved and missed dearly. I am satisfied on the evidence she can only have taken this position under the active influence of her father. She was subject to no other influence which might explain it. She had already made her disclosure when she was observed to enjoy her contact with her grandmother. She knew her mother was in a relationship with Mr. New and what her father made of it, yet, in the early stages, she was open to continuing their relationship. What could have happened to poison that particular well? In my judgment, it can only have been the influence of her father, and his increasingly vindictive and hysterical version of events. Only Mr. Father would have persuaded the child this was a situation in which there were sides to be taken. It is clear it would have been impossible for the poor child even to contemplate sympathy for her mother's side, when closeted with her father, exposed only to his version of the narrative, and left in no doubt of which side he regarded as being the right one. The disloyalty of any other choice, I am satisfied, would have been very plain to her. Initially, girl wanted contact with her mother, and the supervised contact sessions, D16, went well. Ms. CM's records at D24, girl has expressed she does want to have some contact with her mother, but feels very worried. Girl has been seen at home with her mother during supervised contacts. During these contacts, girl has been guarded at the start, but has warmed towards her mother, and has responded positively in her care. Girl had initially asked for the second contact to be made longer, which it was, and this was also observed to be a positive interaction between mother and daughter, and no concerns were raised during these times. However, since this time, girl has expressed she no longer wants to have contact with her mother or speak to her mother, and this view is fully supported by Mr. Father. It was, subsequently, Mr. Father who informed the workers that girl did not want further contact, and he would not force her. The report details how Mr. Father had been obstructive, not only of the court-ordered contact, but also of the social workers' access to girl. The only thing which had intervened was a period of time spent exposed to her father's unchecked and uncompromising narrative. On the January 4, 2020, E200, she is recorded as having said to a police officer that she is very close to her dad, they don't ever really fall out, and explained this is because she doesn't speak with her mum anymore, so dad is her parent. It was Mr. Father who initially reported girl's alleged assertion she was now scared of her mother, because she had assaulted her, Mr. Father's interpretation of what occurred at Madison Heights. It is frankly inconceivable a 12-year-old child would have come up with the description unprompted, and, as I shall set out below, it is not accurate. It was Mr. Father who persuaded girl to the view that her mother had chosen Mr. New over her, and had abandoned her, when, as Dr. H.W. correctly pointed out, if anything it was Mr. New she had chosen over Mr. Father, D125. Had Mr. Father been doing his job as a responsible parent with a proper eye to girl's psychological well-being, he would have encouraged her to consider the plain evidence that her mother had not abandoned her, and was keen to repair their relationship, even to the extent of issuing court proceedings in an effort to overcome her father's obstruction. Far from doing any of that, Mr. Father has clearly encouraged the creation of obstacles to their rapprochement. Girl has subsequently been persuaded to insist on a written response to series of largely provocative and very adult questions before she will meet with her mother. I am quite satisfied Ms. Mother is correct in detecting Mr. Father's hand in this process. It simply is not credible a child of her age would have come up with such a scheme, or embarked upon it unprompted and unassisted. Mr. Father has obstructed access by the social workers to girl, D16, on, as I have already identified, entirely specious grounds. Mr. Father, in my judgment, has been instrumental in girls' decisions to refuse to cooperate with, or even see, the children's guardians. It is, of course, hugely inappropriate that a child in proceedings should be given the impression either that it was her decision to make or that this was an appropriate decision to make. I do not accept it was in fact her decision on any meaningful level. It is a further example of Mr. Father engineering the isolation of the child from those he perceives as not being on his side. For what it is worth, I also do not accept girl's decision to refuse access to her medical records was other than a manifestation of Mr. Father's influence. His purpose is opaque, his responsibility clear. Given that the court had ordered their production as necessary and relevant for the purpose of these proceedings, it is not credible to suggest this anxious 13-year-old discerned for herself she had a choice, and the grounds upon which she might exercise it in the negative. I am quite satisfied she would not have done so without influence from her father. I am quite satisfied the evidence amply supports the findings sought at Allegation 8. Allegation 9. Ms. Mother accepts she cannot point to evidence which would support making a finding in respect of Allegation 9. Allegation 10 is that, on January 5, 2020, Mr. Father and girl attended at Ms. Mother's home in the night and vandalized her car and Mr. New's car. It is suggested this may have been in retaliation for the attendance of the police the night before at the hotel where Mr. Father and girl are living, see para 43 above, because, as has already been established, Mr. Father took the view Ms. Mother had been responsible for the visit, which resulted in a PPO being taken out in respect of girl. This latter without, as far as I have been made aware, a shred of evidence beyond Mr. Father's general presumption Ms. Mother is directly or indirectly responsible for every ill which befalls him. Ms. Mother suggests she is able to decipher from a CCTV recording the voices of both Mr. Father and girl in the course of the incident. Mr. New gave a statement to the police, E258, at the time in which he said he identified Mr. Father leaving the scene in the company of a female who he was not able to identify. Mr. New confirmed in the witness box his confidence the man he saw was Mr. Father. I have viewed the CCTV recording at Mr. Father's request. Mr. Foster accepted at the outset of the hearing he was not proposing to rely upon the CCTV evidence as he is not able to submit with confidence what is discernible from it. Nonetheless, Mr. Father requested I view it. I did, and I accept what he and Mr. Foster, and I understand the police, agree, nothing can be heard or seen which could implicate Mr. Father or girl. I understand what Ms. Mother and Mr. New have said they are able to extract from it, but it is certainly not apparent to the untrained ear. Mr. Father was, as I have said, given the opportunity to file evidence about this incident when permission was given to expand the schedule to include it. He did not take the opportunity to do so. In the witness box he denied he had been there or had done what was alleged. He suggested it might have been a consequence of Mr. New's involvement with illegal drugs in some way. Mr. Father revealed for the first time that he had two people who could provide alibi evidence as to his presence at the hotel where he lives all that evening, making it impossible for him to have been at Ms. Mother's home at the time alleged. At the conclusion of his own evidence he sought permission to call his witnesses, which I granted. Ms. Martin and Mr. Perry made statements as described above, and gave evidence which confirmed Mr. Father's evidence. There is a record in the papers that girl also confirmed they had spent the evening in the hotel, D114. This is an allegation which Ms. Mother makes, and it is for her to prove it on the balance of probabilities. The evidence against Mr. Father rests almost exclusively upon Mr. New's identification of Mr. Father at some distance and at night, albeit Mr. New was entirely confident in what he says he saw. It is not, of course, for Mr. Father to prove anything in respect of this allegation, but he has been able to marshal, albeit somewhat late in the day, compelling alibi evidence. In the circumstances, I am not satisfied to the relevant standard the evidence supports this finding, and I do not find Allegation 10 is made out. Allegation 11, as I have said, is not, strictly speaking, Ms. Mother's allegation, as it did not appear in either of her schedules. However, I have taken the view from a very early stage in the proceedings that the incident involving Mr. Kemp, the process server, was one of some significance from the point of view of the decisions which I have to make in respect of the children's welfare. Accordingly, it has been included as Allegation 11 on Ms. Mother's side, as it is an incident which, if it played out as Mr. Kemp suggests, reflects very badly on Mr. Father. Mr. Foster has been required to present the evidence and submit in support of the allegation Mr. Father behaved in the way alleged. Despite the statement of Mr. Kemp, C9, having been submitted as part of Ms. Mother's case from the earliest stages of the proceedings, Mr. Father did not give his version of events until he stepped into the witness box. Mr. Kemp's statement, made on the same day as the events described, records his attendance at the Barrow Marsh Caravan Park on the morning of 24 September 2018 to serve Mr. Father with the papers in respect of Ms. Mother's application. The man who opened the door of 16C denied he was Christopher Father, but Mr. Kemp had a photograph and was satisfied he had the right man. It turns out his confidence was entirely justified. As he attempted to hand Mr. Father the papers, the latter attempted to close the door of the caravan. Mr. Kemp states he stopped the door from closing on his hand and causing him injury. Mr. Kemp goes on to describe a shocking scene in which Mr. Father subjected him to a highly aggressive and foul-mouthed confrontation, alleging Mr. Kemp had assaulted him, and as he attempted to leave the scene pursuing Mr. Kemp to his car carrying on in much the same vein. Mr. Kemp denied to the site manager, who had been alerted by the fracas, he had assaulted Mr. Father. Mr. Kemp describes Mr. Father as screaming at him to identify himself, which he did, and then denying he had lied when he said he was not Father as his name is Father. Throughout this unpleasant incident, Mr. Kemp reports a young girl was standing in the doorway of Mr. Father's caravan. Mr. Father does not accept this, but he does accept there was no other young girl who Mr. Kemp could have observed in his caravan. Mr. Kemp recalls he felt very nervous, anxious, and intimidated by the extreme aggression shown by Mr. Father, a very rare reaction from his many thousands of serves. In the witness box, Mr. Kemp said he had probably conducted about 1,200 serves since this, and this one still stands out as Mr. Father was among the most aggressive people he had had to deal with. He was confident the girl he described would have heard and seen the whole incident. Whilst he could not remember exactly what was said at the time, when asked for his identity, his practice is to give his name, and that he is a process server. Mr. Father suggested Mr. Kemp had refused to identify himself, and, when Mr. Father tried to close the door as a result of this refusal, Mr. Kemp had broken the blind. This was the first time such a suggestion had been made. Mr. Kemp denied both suggestions and also the suggestion he had called the police. He confirmed his view that Mr. Father was extremely aggressive and was screaming in my face. He firmly rejected the suggestion, once again made for the first time, he had been the aggressor. In response to a question from Mr. Father, he revealed he has had to serve documents on violent people very often, but this was one of the rare cases after which he had contacted the solicitors and informed them he would not accept instructions to serve Mr. Father again, because of the extreme aggression to which he had been subjected. Over a career involving tens of thousands of serves, he had only felt the need to do this about 20 times. Mr. Kemp stated the screaming from Mr. Father had started from the moment Mr. Kemp had stopped him closing the door. It was like a bomb going off. Mr. Father, in his evidence, suggested Mr. Kemp was the one who had been aggressive. When he refused to identify himself, Mr. Father attempted to close the door, and Mr. Kemp had stopped him, thereby breaking the blind. Mr. Father was aware Mr. Kemp was serving documents on him, and went on to remonstrate with him for the damage to his door. Mr. Father denied he had been abusive or aggressive. He seemed to take particular offense at the suggestion. He had been screaming. "I don't scream," he said. Despite his extensive experience of dealing with bailiffs in his campaigning and broadcasting capacity, Mr. Father suggested he had not heard the title process server before, and, had Mr. Kemp identified himself as such, which he did not, he would not have understood what it meant. Girl, he said, was in the caravan with a friend of his, but she did not come out, and would not have witnessed what was not, in any event, a particularly shocking incident. He clearly remembered that. Mr. Father accepted he had been cross about the damage to his door, but did not accept Mr. Kemp had any justification from his behavior to describe the incident as he had. Mr. Kemp must be, Mr. Father told me in his closing submissions, a snowflake. I found Mr. Kemp to be a very impressive witness. He is clearly a mild-mannered man and certainly did not give the impression he might be prepared to be aggressive. I have no hesitation in accepting his evidence and rejecting Mr. Father's. Mr. Kemp gave his evidence clearly and with some feeling. Accepting his recollection of the details was taken from his contemporaneous statement, but having a clear recollection of how Mr. Father's behavior had made him feel at the time. Given my understanding of Mr. Father's character, his version of events is very plainly not true. This is an example of his propensity to explode into rages, which have been described elsewhere, albeit this appears to have been a particularly severe one. It is not possible to say with any degree of confidence what might have triggered this behavior, but I am quite satisfied, beyond the service of the papers in the course of his duty in a calm and measured manner, Mr. Kemp cannot be said to have done anything to provoke it. I am quite satisfied girl was witness to her father's appalling behavior, as Mr. Kemp describes, and Mr. Father was, on this occasion as on many others, quite unconcerned about, and insensitive to, the impact of his behavior on those witnessing it, in particular his own daughter. I am entirely satisfied this incident played out as Mr. Kemp described it. Mr. Father's allegations. Allegation 1 is that Mr. New groomed and sexually assaulted girl. This is obviously a serious allegation and merits careful consideration. It has been investigated more than once by the police, who have determined there is not evidence to support a charge. The social services have considered the evidence and have come to the same conclusion. Neither set of decisions is, of course, binding on me. If Mr. Father were able to satisfy me on the balance of probabilities the evidence supports a finding Mr. New groomed and or sexually assaulted girl, it is a finding I would not hesitate to make. There is a considerable amount of evidence over time which records what girl herself has said to various police officers and professionals. There is even direct evidence of what girl said as recorded by Mr. Father. However, there is also a lot of evidence given by Mr. Father of what he says girl has said. For reasons which I hope will be readily apparent by now, I regard Mr. Father's uncorroborated evidence as unreliable, heavily colored as it is by his not entirely rational take on the situation. Accordingly, I think it instructive in determining this allegation to examine the chronology of the reliable reports of girls' disclosures. I am mindful throughout this analysis that, in circumstances in which children are removed from an environment in which they have been subjected to abuse into a more secure space, disclosures may fill out and the full picture may only become apparent after time. The first in time is the recording made by Mr. Father on the August 29, 2018, and played, apparently, to Ms. XX and Ms. Mother in his car before he made the threat to kill detailed above. It was upon this conversation Mr. Father based his conclusion, firmly held to ever since, Mr. New had groomed and assaulted girl. As it is the supposed foundation stone for the edifice of accusation and vilification, which Mr. Father has subsequently constructed to separate girl from her maternal family, it is worth incorporating in full into this judgment. Dad, you all right, mate? Sorry, so when was the last time he tried to kiss you? Turn it off for a second, I'm not going to talk to you, mate. Girl, hey. Dad, turn it off for a second, I just want to talk to you. He tried to kiss you on the lips. Girl, on the cheek. Dad, right, never on the lips though. Girl, no. Dad, okay, and did you tell him you didn't want to kiss him, or girl, no, I went nah like that, and I pushed him away. Dad, right. How many times has he done that? Girl, quite a few. Dad, but, so he's tried to kiss you. Girl, Dad, has your mum been around? Girl, no. Dad, he's never done it in front of me. Girl, has he not? Dad, no. Girl, oh. Dad, I find it a bit creepy. Girl, yeah, it's a bit weird. Dad, has he ever given you a cuddle, or anything like that? Girl, he gives me he goes like that, like I'm cuddling too but kind of like a godfathery thing I suppose. Dad, he's not your godfather though, darling. Girl, is he not? Dad, no, he's not. Girl, I thought he was. Dad, no. Who told you he was your godfather? Girl, well, this was like a few months ago, we were all talking, it was like oh, New's kind, you said oh well if New's kind of like your godfather, and Dad, he was a REA, he was meant to be a really good friend of mine, but I've never told you he's your godfather 'cause he isn't. Girl, oh I thought you said he was. Dad, no, I never have babe, honestly. Girl, oh. Dad, we don't believe in God. Girl, no, I know but I have godfathers, you know. Dad, okay, right, I want to be honest, has he ever touched you, you know, put his hands on you, stroked you or anything like that? Girl, no. Dad, okay, just hugs and kisses, yeah? Girl, Dad, and you've told him you didn't feel comfortable or girl, no, I said no, I'm too old for that now 'cause he used to give me hugs and stuff like that when I was younger, so why? Dad, because it's not something that he should be doing, is it? Girl, no, not really. Dad, because, I mean I can understand him sort of, if you wanted to give him a hug, him giving you a hug, but him hugging you and kissing you and me and your mum ain't around, girl. He's done it a few times in front of mum, I think, and I think he's done it a few times in front of you as well. Dad, mate, I've never seen it. I've never seen him make a play to hug or kiss you. Girl, no Dad, I've seen you two mucking about. Girl, but sometimes he like walked behind me going RRRR. I kind of class that as a hug cost, then he goes ooh girl like that, so CM, okay. Girl, and then he kissed me on the cheek, like oh I love you so much like that, kind of like a dad. Does he do it to your brothers? Girl, no. Dad, okay. Girl, because they're boys obviously, and they're normally outside so Dad, so there's no one around when this happens. Girl, yeah, there was people around, like Dad, who? Girl, like the boys are like around and George is, he just Dad, no, I mean are they actually in the room? Girl, yeah. Dad, okay. Girl, sometimes Mum's been in the room, sometimes you've been in the room. Dad, I can't ever remember him doing girl, oh yeah. Dad, I mean, like I said, not, him, turn it off for a second, please. Girl, sorry, I just want to know I want to hear what she's saying. Dad, right, wait a minute. Right, okay, and he hasn't done it for a while, no? Girl, not since like the past 2, not even 2-ish weeks. Dad, I don't want you seeing him right now, okay? Girl, all right. Right, inaudible, Dad, yes, course you can. Following a report to the police made by Mr. Father that girl had been groomed by Mr. New, E29, and the latter had been on a WhatsApp group with girl and other girls in which he was known as the Magic Man. On the 9th September 2018, there is a record the police attended 36O Road to interview girl. It seems this was the evening after Mr. Father's arrest for making threats to kill. She confirmed that New had never touched her sexually nor had he said anything inappropriate. She said that he hugs her and kisses her a lot, and that she does not really want him to, and that sometimes the kisses went on a bit too long. I clarified what she meant by too long, to which she made a kissing motion, which indicated a kiss slightly longer than a peck. I asked her about the WhatsApp group, to which she stated that New had occasionally sent her and her friend a magic trick on this, but that is all, and nothing inappropriate occurred. There do not appear to be any offenses. For the purposes of the initial S.37 report, Ms. CMs interviewed the children 8 times between August 31st and October 25th, 2018, D2. It is not clear from her report at which of these interviews any particular piece of reported information was obtained. She records, D24, during direct work with girl we have explored the incident with Mr. New, and girl gave a different account to what was recorded, and a different account to what she shared with the police. Girl stated Mr. New had kissed her on the lips and cuddled her too much. Girl then expressed she had been laying on the sofa, and he came in to say goodbye kissing her on the lips and tried to lay next to her. Girl shared this made her feel uncomfortable. Girl reported that when Mr. New had left she told her mother, but felt her mother did not really believe or take any notice of this. Girl was unclear when this incident had happened but believes it to have been not long after her parents had argued. Girl shared her brothers were not home and her mother was upstairs at the time. It is clear from talking to girl that she has found this uncomfortable and is in need of support to overcome this. On the December 14th, 2018, Mr. Father called the police, E165, stating he was not happy this had not been dealt with by way of a sexual assault. I attempted to explain the rationale, but he just started quoting the 2003 Sexual Offences Act, etc. He also went on to explain that he had received a letter saying that this matter had been put down as inappropriate behavior and was not being dealt with properly. He referred to his ex-partner's new partner as a pedophile. On the December 18th, 2018, girl wrote me a letter, E118. Mr. Father says this was entirely her idea. In it she says, "He's been trying to kiss and cuddle me, and my mum didn't believe me. I hate him. He creeps me out and I never want to see him again. Mum made me go back to his flat and I hated it. He told me he was my goddad when he isn't. I told him not to touch me." On the December 28, 2018, E165, Inspector Tyler reviewed the case because of a complaint by Mr. Father that girl should be AB interviewed. He records that police have spoken to girl, who has not disclosed any offense, and stated her mother's partner new shows her magic tricks on WhatsApp. On the January 11, 2019, E166, Mr. Father reported to the police, Mr. New kisses her on the lips despite her telling him she is not comfortable with it. More worryingly, she states he has held her down whilst lying behind her, in a spooning position. On the January 22, 2019, there was a joint interview with girl at her school, E161. When asked what it was that he had done, she said, "He kisses me, and stuff. I used to allow it as he was a friend of the family, but then it got a bit heavier. And a bit longer. He would always ask for a hug or a kiss. He would sometimes grab her by the cheeks and squeeze them together and kiss her." She said that the last time this happened was 2 or 3 days after mum and dad broke up. She believes this to be around September/October, but the Athena was reported on 29/8/18. Girl was sat on the sofa at home listening to music on her phone. She said that he was also sat on the sofa near to her. She drew a diagram showing that she was one end of the sofa, and he was on the other. She said he then got up and tried to kiss and hug her. She explained it as he went over to her, and leant over the top of her. She explained that New's feet were firmly on the floor, and he did not get onto the sofa with her. She said to him that she needed to go to the toilet, and managed to get up from under his arms and out. She left the room. She said she didn't tell her mum about it as the next day mum was downstairs talking to him. The disclosure came out because dad asked her if New had ever kissed her or done anything, and that is when she told him about it. She said her dad was upset and angry at first, and then he was more worried about the boys still having contact with New. She explained that he started to kiss her on the lips and cheek when she was still around 12 years old. She said that maybe he kissed her on the cheek when she was younger. This was around asking her when it happened. When asked how long the kiss went on, she said around 2 to 6 seconds, but then it moved to being more like 10 to 12 seconds. She said although mum and dad would sometimes be in the house, they did not see. She said sometimes he would kiss her up to 3 times in a day if he was with them a long time. When asked how she felt, she said it was horrible. That she always told him not to do it. She said it was scary and uncomfortable. She said she doesn't want to see New ever again, because what he did was wrong. I asked her what she felt should happen to New, and she said she didn't feel he should have contact with other kids. Girl said that before her parents split there was an occasion whereby she went to his flat on her own. She said her dad was ill and her brothers went to her nan's with her mum, and for some reason she was told she could not go. When asked what happened there, she said that they watched a film. He shut the curtains, which she thought was odd, and she could also feel him breathing on the neck. She said it made her feel very uncomfortable. I asked how they were sat on the sofa, and she said New was sat to her left. She said he did not do anything to her, and when she asked to go home he did offer her to stay longer, but she said she did not want to and he took her home. When asked if he had kissed her on that occasion, she said at the start, and at the end like normal. I suggested a hello and goodbye kiss, and she said yes. On another day, girl said that New had taken her to the shop to buy dead mice for her snake, even though he did not like mice. On the January 23, 2019, the police spoke to Mr. Father about an AB interview, E167. He has stated that he thinks girl just wants to forget about it, so I have suggested that maybe doing an AB interview is not the way forward. He doesn't think Mr. New will make admissions. Therefore the case will remain one word against the other, so getting an evidential account from girl is not necessarily in her best interests. On the March 2, 2019. The police have recorded E172. The social services strategy recorded girl disclosed to her social worker that her mom's partner had come up to her and kissed her on the lips when she was laying on the sofa. She said she was too old for kissing and cuddles, but he continued and her mom did nothing about it. The police concluded there was not enough evidence to suggest a sexual offense, thesis more a case of inappropriate behavior, which can be addressed by social care. 2 other girls, whose names had been supplied by Mr. Father, were investigated. One states New made her feel uncomfortable, but that no offense is disclosed. The mother of the other states her daughter felt very uncomfortable in Joe's sick company, but again no offenses. These are recorded in slightly greater detail in Ms. CM's report, D12. The officer describes Mr. New's reported behavior as worrying. There was no AB interview, and we cannot force her to complete one. Her friends could corroborate her account, but without an identified sexual offense allegation, these prove nothing. I also agree that Mr. Father has an axe to grind with New, who has changed from being a friend to Father's ex-wife's new partner. Mr. Father had obviously been questioning his daughter, and once he identified what he believed to be grooming, he has conducted his own investigation and badgered police to complete a fuller investigation. This does not make him wrong. In her report dated March 26, 2019, D45, Ms. K does not identify when, or even if, she spoke to girl. I assume she must have done at some point. She does not touch much on girl's account of what occurred with Mr. New. Safe to say, D64, girl's account of the incident has not changed in the most recent meeting with the police. Girl is confident in the truth of what she is saying, and it is clear this has had a profound impact on her relationship with Ms. Mother. It is not clear to which of the alleged incidents she is referring. On the January 4, 2020, following the taking out of the PPO, girl told the police officer, E200, she did talk to someone about the time her mom assaulted her and her mom's partner tried to rape her. Not even Mr. Father suggests girl has got this right. Dr. HW spoke with girl in March 2020 for the purposes of his report. He records from his discussions with her, D114, the allegation against Mr. New was about Mr. New kissing and cuddling her when she told him to stop. It made her feel really uncomfortable, and she had to push him away. This had been going on for 2 to 3 years. He concludes, D122, girl spoke of the allegations easily, and without a great deal of emotion. She alleged her mother had set her aside for Mr. New. I am mindful that victims of sexual abuse do not often speak to their adverse experiences, but girl is otherwise an open and engaging child, and spoke about her experiences with ease and without emotion. Mr. Father has, as previously indicated, provided statements from 3 witnesses whose evidence, he suggests, support his allegation that Mr. New has groomed and sexually assaulted girl, AR, C93, her mother KR, C91, and SJ, C94, sister to KR. It is not clear the age of any of these individuals nor when the behaviors of which they complain occurred. None has anything to say directly about witnessing anything between girl and Mr. New. However, Ms. KR reports being concerned by inappropriate behavior by Mr. New towards her daughter AR, aged about 12, hugging her for too long, and saying how much he loves her, and how beautiful she is constantly, and mostly when they are alone, he was over-friendly, making her very uncomfortable. It is unclear how much of the concerning behavior she witnessed herself, but she did see some text messages, which concerned her, as a result of which she asked him to stop texting her daughter, but he did not. She does not disclose anything which appears to amount to a criminal offense, as the police appear to have concluded. IR reports Mr. New has always been in her life as her godfather. His behavior became worrying for her from about 12, giving her gifts, messaging her, being overly affectionate, making her feel uncomfortable, and flirting with her friends who all thought him sleazy. She tried to block him, but he persisted in messaging her and commenting upon her social media. SJ describes Mr. New buying her alcohol from aged 14 and commenting on how beautiful she was. She describes being alone with him once in a park, which made her feel very uncomfortable, the way he looked at her and cuddled her was too much. He made it obvious he liked her. She alleges that Mr. New gave her cocaine in a pub one evening, which she flushed down the toilet. Apart from the possible supply of cocaine to Ms. J when she was obviously of an age to be in a pub without her parents, none of these statements discloses evidence of offenses, and there is no mention of anything which could realistically amount to a sexual assault. As I have said, it is clear that none talks of any behavior with girl, but AR and SJ do say they have experienced what they felt to be inappropriate behavior, which made them uncomfortable and embarrassed. Mr. Father, who, as the police noted, conducted his own investigations to unearth further evidence of Mr. New's proclivities, suggested he had statements from 5 girls who had been the victims of Mr. New. I told him he would be limited to 3 witnesses, and to choose those most supportive of his case. Mr. New denied the suggestion he had ever behaved anything other than appropriately with his friends' children, and had always been affectionate in a friendly way with the children with whose families he was close. His involvement with the WhatsApp group was for the purpose of amusing them with magic tricks, upon request, and he had exited the group soon afterwards. Mr. Father continues to raise concerns about the truth of this explanation, despite it having been confirmed by the children themselves. Mr. New and Ms. Mother remain convinced that girl, and the others, have been put up to the allegations by Mr. Father in his campaign for revenge. I can only base my decision upon the evidence which has been put before me, directly or by reasonable inference. Mr. Father appears to have convinced himself the evidence demonstrates very clearly that girl has been both groomed over a period of time, and then sexually assaulted by Mr. New. I do not suppose anything could persuade him to the contrary. It has dominated the relationships within, and the functioning of, his family for 2.5 years. It is difficult to see how anyone, giving it a rationally objective consideration, could have concluded the content of the recording which initiated Mr. Father's campaign supported the conclusion girl had been the victim of grooming or sexual assault. None of the police officers or social workers involved has ever thought it to be so. It very plainly does not, even ignoring Mr. Father had initiated the exchange by questioning her, and the prompting by which girl is encouraged in her disclosure. At most, what girl describes as being embarrassed and annoyed by Mr. New's attentions. It is Mr. Father who describes it as creepy, a description girl later adopts. Mr. Father has consistently suggested girl is entitled to be believed, and is a truthful child. Nonetheless, she is, apparently, wrong to suggest it was Mr. Father who encouraged his daughter to consider his erstwhile really good friend a godfather. Mr. Father has more recently denied Mr. New was a friend of his at all, being a friend of Ms. Mother's from school. This relatively casual observation from girl transforms very quickly into evidence against Mr. New, proof of his efforts to ingratiate himself with the child for his own nefarious purposes. Despite what she says in the recording, girl is persuaded to the latter view whist in her father's care. The evidence from the child herself is that Mr. Father was responsible for it, not Mr. New, but she is soon persuaded to an alternative view. Girl was wrong, also, Mr. Father says, ever to suggest it was attempted rape. Girl was clear in the recording Mr. New had only kissed her on the cheek, never on the lips, and he never touched her by putting his hands on her or stroking her, just hugs and kisses. She describes godfatherly cuddles for which she considers herself too old. It is Mr. Father who suggests he should not really be doing it, but girl says whatever it is has happened in front of both her parents. It is Mr. Father who suggests he has never seen it. Mr. Father prompts her to agree no one else is around when it happened. She resists the suggestion, and insists people were around, including Mr. Father. The interview concludes with Mr. Father instructing girl he does not want her seeing Mr. New, but there is little evidence of any particular distress on the part of girl caused by what she says she has experienced. The capacity for grown-ups to embarrass adolescents is well established. Mr. New would not be the first to have misjudged the necessity to adjust behaviors as children turn into adolescents and then young adults. Behavior from a familiar adult, which has been entirely acceptable, even welcomed, by a child can quickly turn into unwelcome, embarrassing, and even inappropriate behavior when the same child reaches puberty and/or adolescence. Picking up the cues and making the necessary adjustments is not always easy. Some are better at it than others. It must be particularly difficult for those without the relevant experience from their own children. The process is different for each child and varies among the sexes. It is notoriously something of a minefield, which can result in hurt and embarrassment on both sides. Many adults have been through the wounding experience of rejection of demonstrations of affection, which until recently had been routine, solicited, and important. Some get the message and take it on board more quickly than others. For those who don't, charges of insensitivity, crassness, or even inappropriateness may be justified, but it is a large leap to suggest that such behavior would justify the charge of grooming or sexual assault. It is clear the story in relation to girl commences with what at the very worst can be described as insensitive or even crass behavior. A failure to recognize behavior, witnessed without complaint by her parents, accepted easily within the group of family and close friends, at the very least tolerated without evident complaint by girl herself, was becoming irksome to girl seems to be the worst Mr. New was accused of at the outset by girl. It was a picture which has echoes in the experiences of AR and SJ. The allegations do become somewhat more florid with the passage of time during which, it cannot be ignored, girl was increasingly isolated from many of the more rational influences in her life. Girl's initial narrative transforms itself to something much closer to that which Mr. Father was suggesting to her at the outset. Given all I have already concluded about Mr. Father's influence over girl, and use of her to further his agenda for retribution against her mother, it is not at all difficult to discern his hand in the various versions of the allegations which are reported. She adopts his vocabulary, which becomes her vocabulary. Having started out objecting in very mild terms to behavior for which she had become too old, over the following months she develops a hatred for a man her father hates, and a conviction she is the victim of a man her father early on decided is a predatory pedophile. I have little doubt that girl and her father discussed at some length what she might say about what had occurred between her and Mr. New. It is also clear, from the recording which we have if nothing else, Mr. Father would not have been at all sensitive about avoiding leading her and putting words into her mouth. There is nothing subtle about what he was suggesting to her. Mr. Father himself, as he admits and is clear from the threats to kill incident, took the firm view from the earliest stage of the disclosures he had conclusive evidence of Mr. New's guilt as a predatory pedophile. The questioning makes it clear he was looking for it. There are several examples in the records of Mr. Father taking to the police allegations with greater detail than previously given by girl, clearly obtained by him in conversation with her, some of which she does subsequently repeat, some she does not. What is actually described by girl, even at its worst, simply does not support the allegations which Mr. Father makes. Over the past decade as a society, we have become increasingly sensitive to behaviors which are more clearly understood to be aimed at grooming children, and rightly so. The police and social services are experienced in detecting, investigating, and discerning such behaviors, and the child protection issues are well understood. The authorities are swift to act where it is justified. No system is, of course, entirely foolproof, but those professionals have, at the insistence of Mr. Father, considered the evidence he has marshaled against Mr. New more than once and, together with the results of their own evidence gathering, have neither found evidence of criminality nor of significant concern in respect of child protection. Even without Mr. New's side of the story, the worst interpretation of his behavior is it was inappropriate. Had this been a more functional set of relationships, it is the sort of behavior which could have been settled by taking the adult to one side for a quiet word to inform him of girls' changing sensitivities. Even if Mr. New had proved as stubbornly resistant to the message as the other witnesses suggest, the solution would have been avoiding or blocking him, as it apparently was in the other cases, not public vilification as a pedophile and criminal investigation. The most that can be said about the evidence, which can be shown to come more or less reliably from girl herself, rather than reported by her father, is it demonstrates a crass and insensitive failure on Mr. New's part to pick up the cues from girl as to the changing acceptability of his behavior. That is how she described it at the outset. Subsequently, I am satisfied her continued disclosures are irredeemably tainted by unmoderated exposure to her father's objectively unjustified and frankly irrational determination of guilt. The longer girl has spent effectively isolated in her father's care, the less reliable has become anything which she contributes to the body of evidence in respect of M.New's behavior. For that, Mr. Father bears the responsibility. I am not satisfied the evidence supports the findings of grooming and sexual assault, which Mr. Father seeks. It did not happen. Allegation 2 is that in 2005 Ms. Mother sold and regularly used cocaine. The evidence relied upon by Mr. Father in support of this allegation is his own testimony unsupported save for the admission made by Ms. Mother to Ms. Siems in the preparation of the S.37 report, D11. Ms. Mother accepts that Ms. Siems recorded the wrong year. It was 2005, not 2008, and it is correct, following a raid on the house, which she says was triggered by Mr. Father's activities. She was arrested for supply of drugs, but she was never charged. She has made allegations, which do not form part of her own schedule, that Mr. Father has long been a user and dealer of illicit narcotics. I have dealt with the police records of involvement with Mr. Father above. I accept Ms. Mother's admission she had used cocaine in the past, but she stopped before the children were born. Beyond that, there is only Mr. Father's uncorroborated allegation, for which he produces no supporting evidence. The evidence supports a finding that Ms. Mother used cocaine before her children were born, but not that she sold it. Allegation 3 is that Ms. Mother assaulted girl at Madison Heights. Mr. Father was not present at this incident, which took place after the parties had separated, after Mr. Father had recorded and broadcast girl's initial disclosure, and after he had forbidden girl from seeing Mr. New. Girl met up with her mother and siblings to go skating. At the end of their time together there was a suggestion, it seems, that Mr. New might join them. I'm not entirely clear whether he actually did or not. Girl voiced some resistance to seeing Mr. New, would not get into the car, and Ms. Mother reacted badly. Ms. Mother accepted in her evidence she is not proud of her reaction, but she does not accept she assaulted girl. What seems to have occurred is that Ms. Mother, in frustration or anger, slammed her hand onto the steering wheel and/or the headrest of the seat in the car. Girl was alarmed and upset by this, and subsequently suggested she thought her mother might hit her. The contemporaneous report to the police, E68, shows Ms. Mother took the children to the police station because she said she was worried girl was otherwise suggesting she would walk home to avoid seeing Mr. New as her father had told her the social services did not permit it, a suggestion which if accurate was not in fact correct. The officer advised Ms. Mother to deliver the children to their grandparents' home, whence Mr. Father could collect them without risking breaching the orders to which he was subject. Sometime later Mr. Father attended the police station with all 3 children and requested the officer speak with girl as she was upset and scared. The officer records girl saying her mom was having a go at her, and when she was in the car she thought that her mom was going to hit her, although no movements appear to have been made. Girl reported to Ms. Siems she had been scared of her mother for the first time, D24, and thought she might hit her. In her letter to me, E118, she wrote she did not like or want to see her mom because she calls me a liar and scares me because she went mad at Madison Heights and has picked him over me. In the joint interview, E161, she said mom started shouting at her as she asked why New was there and mom said that dad was manipulating her and raised a fist. She said she did not hit her but hit the headrest. Ms. K records in her S.7 report, D35, referring to the same incident, she is scared of Ms. Mother and worried what she might do. Girl states that Ms. Mother hit the headrest and was very angry. She also deals with the fallout from the incident at D65. By January 2020, E200, at the latest girl was describing the incident as an assault on her by her mother. Putting on his legal thinking cap, Mr. Father's researches have revealed to him that an assault can be committed in circumstances in which a person causes another person to apprehend the immediate use of unlawful violence. This says Mr. Father was an assault. It is abundantly clear he has told girl as much and, as time has passed, his vocabulary has once again become hers. Ms. Mother clearly is ashamed of and regrets her loss of control on that day. So much was obvious in the witness box. She does not accept this was an assault, and suggests the whole incident has been blown out of all proportion. I agree. Save in the most arcane and unrealistic application of the legal definition, this cannot possibly be described as an assault. The incident was, on the evidence, largely provoked by Mr. Father misrepresenting the situation to girl, and irresponsibly placing her in the invidious position of having to enforce his restrictions on the circumstances in which she could spend time with her mother and siblings. If every momentary, if regrettable, loss of control by a frustrated, or even angry parent, which resulted in alarm to his or her children were to be classified as an actionable assault, the courts would be swamped. It is the sort of incident which, to a lesser or greater extent, plays out multiple times each day across the country, and, where there is no one involved keen to make a mountain out of a molehill, quickly passes without more than a ripple. Whilst I accept it was less than ideal behavior by Ms. Mother, the fact this has subsequently come to loom so large in girl's mind is, I am quite satisfied, almost exclusively the irresponsibility of Mr. Father in convincing girl it was something which it was not. In my judgment, the evidence does not support a finding that Ms. Mother assaulted girl. Allegation 4 is that on September 12, 2018, Ms. Mother left the 3 children locked in the house while she went to see Mr. New. It was, apparently, boy 1 who reported to Mr. Father he had been left alone to care for 2 younger children. With his now familiar lightness of touch, Mr. Father's videoed an interview with boy 1 on the subject, and went off to the police station to report Ms. Mother for neglect. Ms. CMs, D19, watched the video supplied by Mr. Father, and spoke to boy 1. She states that boy 1 was clearly not visibly distressed, as reported by Mr. Father, and boy 1 told her nothing scary had happened whilst his mother went next door to sort out her phone, adding it was a little scary as the dog was no longer at home. Far from playing up, as Mr. Father alleges, the children were all playing on the Xbox. Mr. Father told the police the children had been left alone for 45 minutes, while their mother went to see Mr. New. Ms. Mother, when spoken to, agreed she had gone next door for about 15-20 minutes to try to sort out a phone issue. She checked on the children every few minutes, the back door was open, and the children knew where to find her. This was the explanation she gave in the witness box. There is not a shred of evidence to suggest anything else was the case. This is a stark example of Mr. Father making trouble out of almost nothing. The evidence does not support a finding the children were locked in the house and neglected. Allegation 5 is that in September 2017 Ms. Mother assaulted Mr. Father by throwing a phone at him, witnessed by girl. The evidence which he identifies in support is his own report to Ms. CMs, D58. Ms. Mother denies it. Despite extensive involvement with professionals in which she has reported a number of things, girl has never mentioned this. There is no other evidence at all of this alleged incident. I am satisfied the evidence does not support this finding. Allegation 6 is that Ms. Mother has lied to the police, professionals, and the court on several occasions. The first suggestion is she lied about the existence of CCTV evidence of his threats to kill her. The evidence was not produced. Ms. Mother suggests it was given to her then solicitors, and she has no explanation why it was not subsequently produced, but as far as she is aware it was given to the police. There is nothing to gainsay that explanation, and I am satisfied the evidence does not support a conclusion she was lying about that. The second relates to the contents of paragraph 20 of Ms. Mother's statement at C5, and the police report at E95, in which Ms. Mother reports her concerns that Mr. Father had removed the children from school on 12 September 2018, and she did not know when they would be returned. Mr. Father suggests this was a lie because she had been told by the headmaster Mr. Father had told him they would be home by 8 p.m. Ms. Mother's not unreasonable response to that suggestion was Mr. Father's word was not to be trusted. As it was the boys were returned but not girl. I do not find the evidence supports a finding she lied on this occasion in her statement. The third suggestion was something to do with her attendance at Malden Police Station on January 24, 2019, to make inquiries about the joint interview, which had taken place on the 22nd. I was not entirely clear from Mr. Father's questioning what the allegation was in relation to this. It was somewhat incoherent. I could discern nothing in Ms. Mother's answers, which gave me any cause for concern as to her honesty on this occasion. Allegation 7 is that Ms. Mother was implicit of abuse suffered by girl by failing to safeguard and ignoring her. The allegation of complicity in the abuse is founded upon Mr. Father's allegation that girl was the victim of abuse, which I have already found to be unsubstantiated. Insofar as there was anything from which to safeguard girl in relation to Mr. New, which I have already concluded amounted to nothing more than crass and insensitive behavior at worst, it is clear from girl's own evidence that both parents were witnesses and equally complicit. This allegation has no substance. There is no evidence to support this finding. This judgment will be circulated to the parties in advance of the next hearing and formally handed down at 11:30 a.m. on July 10, 2020 at a remote hearing by telephone. Consideration will be given to the progress of the applications in light of the findings made in this judgment. All parties are reminded of the confidentiality of these proceedings, and that nothing should be published which risks identifying the children. Please read the warning at the head of this document. The time for any intended appeal will commence on July 10, 2020, and runs for 21 days. Important notice: this judgment was delivered in private. All persons, including representatives of the media, must ensure the anonymity of the children, and members of their family must be strictly preserved. Failure to do so will be a contempt of court. Case No. CM 18P02684 in the Family Court at Chelmsford. Date: May 18, 2021. Before HHJ Lochrain between mother applicant and father. Girl, boy 1 and boy 2 by their children's guardian Ms. R.W. First respondent. Second respondents. Mr. Foster for the applicant, father in person, Ms. J for the second respondents. Hearing dates: 6th, May 7th, 2021. Judgment, final. Numbers in are bundle page numbers in the typed numbering. HHJ Lochrain. This is the judgment at the conclusion of a 2-day hearing to determine the final orders to be made in respect of 3 children, girl, DOB 06, boy 1, DOB 08, and boy 2, DOB 11. Their parents separated in 2018 in circumstances which feature centrally in this litigation. The children have been the subject of proceedings ever since. There are cross-applications for live with and spend time with orders. The children are represented by their R16.4 guardian, Ms. R.W. She is the second guardian appointed in these proceedings to represent the children. Girl lives with her father and currently does not see her mother. Boy 1 and boy 2 live with their mother and have been seeing Mr. Father in a supported/supervised arrangement intermittently. The time which the boys have spent with their father has been affected by the availability of what has hitherto been considered appropriate supervision, combined with the impact of the pandemic. The latter has inevitably complicated the availability of face-to-face professional supervision, but also has impacted the ability of the professionals, Dr. H.W., and the children's guardian in particular, to meet in person with the protagonists and the children. Mr. Father has represented himself throughout. At this hearing he has been assisted by Ms. Lewis as a Mackenzie friend. Ms. Mother has at this hearing been represented by Mr. Foster of counsel, and the children's guardian has been represented by Ms. Jenkins. I remind myself at the outset that the welfare interests of the children are my paramount consideration. Each child is entitled to separate consideration of his or her welfare interests. The court may only countenance interference with the parties' rights to a family life, where it is shown to be both proportionate and necessary in the children's welfare interests. Ms. Mother has throughout these proceedings sought to have girl extracted from Mr. Father's care and returned to her household where she, her partner Mr. New, and boy 2 and boy 1 are living. She has maintained for some time that contact between any of the children and their father should be professionally supervised for the foreseeable future. These proceedings were issued in September 2018, so it has taken nearly 3 years for them to reach a conclusion. As a result, Ms. Mother reluctantly accepts that removing girl from her father's care now would, even if it were physically possible, prove more damaging to girl in the short term than leaving her there, albeit she asserts Mr. Father's environment is one which continues to be abusive and contrary to any objective assessment of girl's welfare interests. She wishes to promote inter-sibling contact as long as Mr. Father is not a part of it, and hopes that girl will eventually allow their relationship to be repaired. Ms. Mother continues to maintain that anything other than professionally supervised contact between the boys and their father would not be in their welfare interests. Mr. Father continues to dispute the findings made against him at the conclusion of a fact-finding hearing, although he is content to accept I was correct when I made findings adverse to Ms. Mother, particularly in respect of her Allegation 10. The allegations against him, conversely, he maintains are all false, or at least exaggerated, and have no supporting evidence whatsoever. He disputes the conclusions of Dr. H.W., the psychologist appointed on the instructions of the children's guardian, and the children's guardian herself. The former, he suggests, is a completely corrupt charlatan. He has manufactured a case against Mr. Father on the instructions of the children's guardian and her solicitors in return for excessive fees and the promise of more of the same in the future. He is hired as a hatchet man. The children's guardian is incompetent and unprofessional. She has effectively bribed Dr. H.W. to support her vendetta against Mr. Father. He persists in his allegation that Mr. New is a predatory pedophile, that Ms. Mother is complicit in his depredations, and that no child is safe from him, particularly not his own children, most especially girl. Mr. Father suggests all the children should be in his care as he is well recognized to be the better parent, and he will foster contact between them and their mother as long as it is safe. He, in consultation with the children, would determine whether and, if so, when it is safe. The children's guardian reluctantly concludes that attempting to remove girl from her father's care after nearly 3 years, during which she has been exposed to his unchallenged and unmoderated narrative, would be more damaging than leaving her there. She does not suggest that Mr. Father's environment is a healthy one for any child, but the bleak future for girl in her father's care is marginally to be preferred to the trauma which would inevitably result from any attempt to separate them after all this time. Ms. R.W. is firmly of the view that contact between the boys and Mr. Father needs to be professionally supervised for the foreseeable future, but that inter-sibling contact should take place in as relaxed an environment as possible. To the latter end, she suggests the children should meet at their paternal grandmother's home, under clear instructions for her about the need to ensure Mr. Father does not infiltrate it in any way. If the paternal grandmother proves inadequate to that task, it will have to be rethought. On July 10, 2020, I delivered a lengthy judgment at the conclusion of a 3-day fact-finding hearing which had taken place in June. Subsequently, Mr. Father has informed me on more than one occasion that he proposed to appeal those findings. I am still not entirely sure whether Mr. Father did in fact appeal. However, I am clear there has been no successful appeal. Although Mr. Father continues to maintain the findings made are wholly wrong as they are based on either false or exaggerated allegations, he has not taken the opportunity to file any evidence of any substance which gives me any cause to revisit those decisions. In the course of the evidence during this hearing, Mr. Father has had the opportunity to cross-examine Dr. H.W., which he did not have the opportunity to do in the fact-finding hearing. I shall return to the evidence of Dr. H.W. in due course, but I can say at this stage that, if anything, the doctor's evidence in this hearing served to reinforce the earlier findings I made, rather than disturb them in any way. In one minor respect, the evidence in this hearing has potentially impacted upon my findings in the earlier fact-finding hearing. At para 64 in that judgment I said, I accept Ms. Mother's evidence that the children have been disciplined at school for repeating offensive words and gestures. In her evidence in response to questions from Mr. Father at this hearing, she accepted she was unaware of the schools having reported disciplining the boys in this respect. I have not had the opportunity to revisit the evidence upon which I based that finding, but I accept now Ms. Mother's evidence is different. As will be appreciated from a reading of the fact-finding hearing judgment, this is a very minor finding, and this development does not in any way affect the findings I have made in respect of the other allegations, nor the conclusions which I reached on the evidence generally, which are set out in some detail in the judgment. Subject to that minor observation, I adopt the judgment of July 10, 2020 for the purposes of this judgment. It has been a feature of this hearing, as it has been consistently throughout the proceedings generally, that Mr. Father makes complaint the professionals have not been appropriately communicative with him, and he has not been given proper access to the documentation and the bundles. The children's guardian's solicitor has shouldered the burden of communicating with Mr. Father in connection with the progress of the proceedings, but at an earlier stage insisted that she would no longer accept telephone calls from Mr. Father. Almost all communication has been in writing. Mr. Father has throughout the proceedings maintained he has difficulty in receiving documentation by email. He has, except on rare occasions, declined to attend at the solicitor's offices to collect papers, and has regularly maintained he has not received documents which have been posted to him. He has an email address which has been assigned to him in his role as parish councillor, the use of which for private purposes, particularly these very private purposes, he has understandably rejected. At several points in the progress of the litigation, he has suggested he will set up a private email address in order to facilitate his participation in the proceedings. He has never succeeded in achieving this. Mr. Father has more recently maintained that he has no proper equipment or access to the internet to enable him to operate a private email address, and that he cannot receive documents electronically. Mr. Father has throughout given the impression he feels he is under no obligation to be proactive or put himself out to any great extent in order to ensure he has all the relevant documentation. On November 9, 2020, I held a directions hearing in preparation for this conclusion of the welfare stage of the proceedings in respect of the children. The hearing was held by telephone conference and Mr. Father was present. At that hearing, a pre-trial review hearing was scheduled, once again by telephone conference, for April 28, 2021 at 10:00 a.m., and the final hearing was listed for 6th and May 7, 2021 with the parties attending in person. In addition, among other things, the parents were required to file and serve statements of evidence upon which they proposed to rely at this hearing by 16.00 on April 9, 2021. During the course of this year, Mr. Father has finally agreed to collect a copy of the bundle from the children's guardian's solicitor's offices. He now, May 6, maintains it was incomplete, but he does at least accept it contained a copy of the order of November 9, 2020. Mr. Father did not attend the PTR. He did not answer several calls made to his phone for the purpose of connecting him to that hearing. He had not, by then, filed or served any evidence, although Ms. Mother had complied with the direction. The children's guardian's filing of her final analysis was delayed, in part, because of the absence of Mr. Father's evidence. In respect of his non-attendance at the PTR, he first suggested he did not know it was taking place. When reminded of his attendance at the hearing on November 9, 2020, the provision to him of a copy of the order, and the several attempts to join him on the day, he further suggested he had not participated because he felt he had not been provided with all the relevant documentation. Had he participated in the PTR, he could, of course, have aired his concerns about any missing documents, and those problems, together with the oft-encountered communication issues, might have been capable of resolution. This, indeed, was in large part the purpose of the PTR. For this hearing, Mr. Father attended on the first day with several copies of a statement, which exhibited numerous pages printed out from what he subsequently alleges are social media sites, notwithstanding his apparent historical and current difficulties with documents and the Internet as set out above. The statement does not provide any information about the alleged provenance of any of the exhibits, or the conclusions which he suggests should be drawn from them. However, in the course of his cross-examination of Ms. Mother, it became apparent he suggests some of the exhibits show both she and Mr. New have breached the obligation of confidentiality in respect of information obtained in the course of these proceedings. Ms. Mother has accepted responsibility for one page, and I shall return to that in due course. The other documents printed by Mr. Father from the internet show he subsequently suggests similar wrongdoing by Mr. New. On the face of them, it is impossible to tell where they have come from or who might have been the authors. Mr. Father gives no evidence in respect of these matters. Ms. Mother denied any knowledge of them, and Mr. Father was not in a position to prove anything else. The evidence before me is comprised in the statements and documentary evidence, which were produced for the fact-finding hearing together with updating material. Dr. H.W. has filed an addendum report dated October 19, 2020. Ms. Mother has filed 2 further statements on the 9th and April 29, 2021, and the children's guardian filed her final analysis dated May 4, 2021. As I have said, despite the directions given in November 2020, Mr. Father did not file any evidence until he attended on May 6 with copies of a statement dated May 5. He complained that he had not received Ms. Mother's final statement, nor a copy of the children's guardian's final analysis. His justification for producing his evidence at the very last minute being that he had not, once again, been provided with all the relevant documentation. This situation might well have been avoided had he chosen to participate in the PTR, and, of course, his statement was supposed to be filed at the same time as Ms. Mother's and before the children's guardian's final analysis in any event. As it turned out, Mr. Father's statement did not deal with any of the evidence, historical or more recent, save obliquely to attempt to revisit the question of the threat posed by Mr. New. Otherwise his statement is nothing more than a general set of proposals for the children's future care, accompanied by the unidentified and unexplained exhibits. In the course of the hearing much time was lost because Mr. Father needed time to read the children's guardian's analysis. Dr. H.W. gave evidence by video link and, much of the time on the first morning, when he was booked to give evidence, having been lost to allow Mr. Father to read the analysis, he generously agreed to make further time available on the second morning to complete his evidence. Ms. Mother gave evidence and was cross-examined at length, but broadly appropriately, by Mr. Father. The latter gave evidence and was, in the circumstances, asked very little in cross-examination, his flat rejection of the findings and persistence in his disproved allegations against Ms. Mother and Mr. New, by then at least, being very apparent. Finally, the children's guardian gave evidence and was cross-examined by Mr. Father. Ms. Mother's statements make it plain how disappointed and frustrated she has been by the process, by the apparent lack of concern by the social services, and, more recently, what she perceives to have been the unavailability of the children's guardian. She contrasts this with what she perceives to be the support given to Mr. Father despite the findings made against him. In her evidence during the hearing, she confirmed her position, as set out above. She disputed that she had refused to attempt to meet with girl in the company of Ms. Lewis. She said she had taken the advice of the social worker Adele that the first meeting should be with her, and she suggested she would be happy to meet girl with Ms. Lewis, but wanted to meet Ms. Lewis herself first. Unfortunately, to date there has been no meeting between girl and her mother, whether with the social worker or Ms. Lewis. She denied any knowledge of the alleged postings exhibited to Mr. Father's statement, apart from accepting she was the author of the page which starts biting my tongue. She accepted she was wrong to have posted this information, and said she had very swiftly taken it down. She had posted it in frustration. Much of Mr. Father's cross-examination of Ms. Mother was taken up with attempts, without any additional evidence, to revisit with her the findings made at the fact-finding hearing. Dr. H.W. confirmed that he stood by the conclusions set out in his reports. He demonstrated commendable patience when responding to a line of frankly fairly offensive and insulting questioning from Mr. Father. The latter asked Dr. H.W. whether he was aware of a website which contained, apparently, numerous allegations against the doctor in his professional capacity. No details of those allegations were provided by Mr. Father. Mr. Father suggested these demonstrate that Dr. H.W. is a charlatan, my word, not Mr. Father's, and that he was guilty of serial and serious professional misconduct. Dr. H.W. confirmed he was aware of the existence of the site, but had not dwelt on its content. No complaint had been upheld. Without even attempting to identify, or even refer to any evidence which might support such a suggestion, Mr. Father accused the doctor of being a hatchet man who would say anything if he was paid enough. The doctor, he suggested, had conspired with the children's guardian to fabricate his evidence against Mr. Father in return for lucrative further business. In the circumstances, the doctor declined to comment. He confirmed that he had not been in a position to make a formal diagnosis of a personality disorder in Mr. Father, but that he had identified a number of concerning traits in him, which might contribute to such a diagnosis were Mr. Father to submit himself to an appropriate investigation. Dr. H.W. detailed the time he had spent on his investigations, in person and remotely, and confirmed he felt he had had enough time properly to form his conclusions. Dr. H.W. agreed that publication of information on the Internet concerning the proceedings, and either parent's allegations against the other did run the risk of causing distress to any of the children. Dr. H.W. said the real hindrance to contact between girl and her mother recommencing is that girl has developed a false belief of inappropriate touching by Mr. New which, in her mind, makes such contact inappropriate. This is very unhelpful for her. There should if possible be contact so that girl can have a chance to develop a more rational understanding. This is not about her having been abused by Mr. New, but having to side with her father. He said he had previously advised girl should be moved to live with her mother, because of the conduct of her father which he considered to be abusive. The latter will fight heaven and hell to promote his false beliefs and illusions. Girl, he concluded, is subject to considerable manipulation by her father, and, in the circumstances, Dr. H.W. felt the impressions documented by some other professionals since the family breakup had to be treated with caution. He preferred to make his own judgment. Dr. H.W. confirmed that, following the fact-finding hearing judgment, he no longer suggested Ms. Mother has narcissistic traits. He thought her highly intimidated and frightened when around Mr. Father, but the fact that she clearly tolerated or even encouraged affection in the boys for their father demonstrated she was not attempting to induce a psychological split between them. Conversely, in her father's environment, girl has clearly developed negative feelings towards her mother. Dr. H.W. said, I cannot emphasize strongly enough how concerned I am about this 15-year-old and the care of her father. This is because of the false narrative induced by her father. I have no doubt this child loves her mother, but she is not allowed to love her mother. To place her back with her mother would put her back in a place of reality, and would be to her advantage. Nonetheless, he accepted that, as things stand, it is no longer practical to expect girl to comply with an instruction to return to live with her mother. He said the evidence girl is doing well at school is a familiar picture in such cases. School is an environment away from the negative influences at home where she may continue with her real life without fear of the consequences. Mr. Father gave very little evidence, his statement containing little of material assistance in resolving the welfare issues relating to the children. It is apparent from his questioning of others and his interjections during the course of the hearing that he has not moved at all in his thinking or insight since the conclusion of the fact-finding hearing. The findings made in June and July 2020 are rejected comprehensively, save insofar as they are made against Ms. Mother. Otherwise, the conclusions of the judgment are wrong, arrived at without any support from the evidence, because the judge had taken a personal dislike to him. He remains, in his own eyes, a kind and generous man, who is only guilty of fighting to protect the reputations of his children. Mr. Father maintains Dr. H.W. and the children's guardians are in cahoots, incompetent and corrupt. They have fabricated a case against him without any justification at all, and without adequate investigation or time spent with him or the children. His trawls of the Internet have provided him, as far as he is concerned, with conclusive evidence, from the unsubstantiated complaints of others apparently dissatisfied with these professionals, that he is correct in his assessment. Somewhat typically, the absence of objective rational evaluation and due process seem only to lend such allegations greater credibility in the fetid swamp of Internet conspiracies. His own experiences of having been trolled on the Internet and being the victim of apparently untrue, hurtful, and damaging allegations by those wishing him ill, do not appear to have persuaded Mr. Father to give the smallest benefit of the doubt to these professionals. Mr. New, he states, remains a proved predatory pedophile, any judicial conclusion to the contrary being obviously contrary to the evidence. In my earlier judgment, I dealt with the evidence in respect of this allegation at great length, between paragraphs 104 and 137. In his questioning of Dr. H.W. on this subject, Mr. Father was focused entirely on one comment made by a police officer, E172, which describes Mr. New's behavior as worrying. Mr. Father suggested this was a conclusion of greater authority than any other, and clearly indicated the police had decided Mr. New was a threat to children, as Mr. Father has maintained since Ms. Mother chose him over Mr. Father. He suggested the source of the comment, a D.C. Blackburn, was a highly expert officer investigating child sex offenses, and her apparent view of the danger presented by Mr. New was obviously to be preferred to Dr. H.W.'s, the children's guardians, or, indeed, a judge's. In fact, the comment referred to appears to be made by a D.S. Crook-Williams as part of the police decision to attempt to obtain Mr. New's side of the story, which had clearly not been obtained when the comment was made. This comment, upon which Mr. Father places such reliance, and which, he told me, proves that I have got it wrong in my earlier judgment, has been taken by him out of context. The comment and its context are dealt with at paragraphs 116 and 117 of my earlier judgment. It is explicit in the report, even before hearing Mr. New's version, which the officer thought was unlikely to deliver further evidence, there was insufficient evidence to conclude any sexual offense had been committed. Ignoring completely the context of the comment, and the analysis of the rest of the evidence contained in my judgment, Mr. Father appears still to be convinced this proves he is right and everyone else is wrong. He continues to assert he is only supporting girl in making her allegations. For the lengthy reasons set out in my earlier judgment, supported by both the children's guardian and Dr. H.W., that is an unreliable perversion of the probable reality. Ms. Mother and Mr. New, benefit scroungers, he suggests, are unfit to look after the children. Mr. Father asserts he is widely recognized as the better parent. He allegedly remains convinced that Mr. New is a threat to his children. They should all live with their father, he suggests, whence they will be able to enjoy contact with both the paternal and maternal sides of the family, as long as it is safe. The children's guardian also gave evidence, and was questioned on behalf of both parents. She too confirmed the amount of contact she had had with the various players in this drama. Her availability to communicate with anyone had been hampered in the early part of this year by significant IT issues, followed by a lengthy period of leave which she had to take before the end of March. Albeit that she had not been able to spend as much face-to-face time with them as she might have chosen to do in less troublesome times, she was confident she had been able to do enough to reach robust conclusions. Ms. R.W. asserted she has a very good knowledge of the case, and has made a balanced recommendation on consideration of all the evidence. Ms. R.W. was clear that there remain considerable concerns about girl remaining in the care of her father. However, girl is clear she wishes to remain in the care of her father, and, given her age, any alternative outcome could not be imposed without significant trauma for girl. Mr. Father was very critical in his questioning of the children's guardian, suggesting she had failed to establish a relationship of trust with girl. In response, Ms. R.W. pointed out that Mr. Father had consistently informed both children's guardians that girl did not want to communicate with them by phone. Ms. R.W. was clear that Mr. Father had restricted access to girl, who had, in the early stages, been open to communicating fully with her guardian, but subsequently had apparently declined. Ms. R.W. denied that she had failed in her professional duties, and that she had been antagonistic or unhelpful in her dealings with girl and Mr. Father. Ms. R.W. expressed herself disappointed that the inter-sibling contact, which had been contemplated at least as late as the November 2020 hearing, had not yet taken place. She felt, if it can be made to work, the paternal grandmother's home would be the most relaxed environment in the circumstances. The paternal grandmother would have to have read the fact-finding judgment. She would have to be clear that Mr. Father must not be permitted to participate or intrude in any way, directly or indirectly, the contact should take place at her home, not in the community. She must be vigilant to discourage discussions among the children which involve negative parental attitudes on either side, and she must understand her primary obligation to report any attempt by Mr. Father to intrude. On the morning of the second day of the hearing, the children's guardian spoke to the paternal grandmother and arranged to discuss these matters with her further. She said that, during this hearing, as a result of what she had heard from Mr. Father, she had become less confident that the paternal grandmother would be able to deliver this package and protect the children. Nonetheless, she still felt it is worth trying before a more impersonal and restrictive regime is put in place. Ms. R.W. agreed it would be useful for the expectations of the paternal grandmother in this context to be put in writing and for her to sign up to them explicitly. Ms. R.W. has expressed concerns about the amount of information about these proceedings and related adult issues, which is being shared with the children on both sides. Mr. Father's attitude to sharing such matters with girl is fully set out in my earlier judgment. However, the children's guardian was concerned that boy 1 in particular appeared to know more than was desirable, particularly about Dr. H.W.'s diagnosis of Mr. Father. She was sympathetic to Ms. Mother's frustrations and alive to the problems potentially created by the children having sibling contact when girl is immersed in her father's unmoderated narrative, but the boys are not similarly informed of the more balanced and rational maternal narrative. Nonetheless, she emphasized the point that both parents had a continuing obligation to protect the children from exposure to these adult concerns. Ms. R.W. has generously offered to continue her involvement following the conclusion of these proceedings for the limited purpose of liaising with the paternal grandmother and, importantly, explaining to the boys why their contact with their father must be supervised by strangers. She has offered to advise Ms. Mother on how best to ensure the boys understand the maternal narrative as a counterbalance to what they are likely, initially at least, to hear from girl. It is a source of some considerable regret, but sadly not a great surprise, despite the wealth of evidence in support of the findings made in my earlier judgment and the updating evidence filed subsequently. Mr. Father remains totally resistant to any criticism of him or his behavior hitherto, and entirely satisfied that his allegations against Ms. Mother and Mr. New are true. As I have said, the evidence which I have considered for this hearing has, if anything, confirmed the accuracy of the findings previously made. I have little doubt that the children's situations would be improved immeasurably if their father were able to reflect upon the evidence and the findings and begin to seek help to address the problems which are manifest. Mr. Father clings to the confirmation provided by Dr. H.W. importantly, that he has not been, as far as we know, the subject of a formal diagnosis of any psychological or psychiatric disorder. I say as far as we know, because not all Mr. Father's medical records have been disclosed into these proceedings. In Mr. Father's mind, this is conclusive evidence of the fact he does not have either. Mr. Father sees what he wants to see and hears what he wants to hear, irrespective of what objective or rational consideration of all the available evidence might indicate. He might do well to heed the sage advice of Mr. Jaggers: take nothing on its looks, take everything on evidence. There's no better rule. The lack of a formal diagnosis does not, of course, mean the same as a formal diagnosis excluding some potential condition. It is axiomatic that at any one time there are many people who are suffering from conditions, mental or physical, which have for whatever reason not yet been formally diagnosed. The lack of a formal diagnosis does not make them any less real or potentially dangerous. The lack of a formal diagnosis does, however, generally mean the condition remains untreated. In this case, Dr. H.W. has identified, from his own experience and from consideration of Mr. Father's available records, traits in Mr. Father which could support a formal diagnosis of a personality disorder in Mr. Father if he were to submit himself to such a diagnostic investigation. On current form, this is extremely unlikely to happen. What this means is not that Mr. Father has a clean bill of health. It means we do not yet know what a formal diagnostic investigation might conclude, but there are troubling symptoms which remain untreated. I entirely reject Mr. Father's suggestion that Dr. H.W. and the children's guardian are in some sort of corrupt conspiracy. He advanced this theory during the fact-finding hearing, and I dismissed it then. See paras 23 and 33 in particular. It was self-evidently baseless and fanciful then, and it remains so now. I'm afraid it is still symptomatic of Mr. Father's response to anything with which he disagrees. It is sad that he remains at best incapable of taking a step back and accepting that his attitudes and behaviors have created entirely legitimate concerns in the assessment of the professionals charged with the task of advising the court on the children's welfare. I have remarked in the past that Mr. Father is an intelligent person, and I'm afraid it remains a possibility that he fully understands what he is doing and obdurately refuses to accept any implication of fault on his part as he continues to pursue his vituperative and vindictive quest for vengeance against Ms. Mother and Mr. New. His allegations remain baseless and his pursuit of them either irrational and delusional or calculated and malicious. Either way, the children have been caught up in his campaign, either deliberately involved or not protected from it, and their relations with each other, their parents, and their extended families seriously, and possibly irreparably, damaged. I understand that, to a lesser or greater extent, both parents have expressed dissatisfaction with the performance of the children's guardians, and Mr. Father has been particularly critical of the amount of time devoted by Ms. R.W. and Dr. H.W. to the investigation of the issues before reaching a conclusion. Both these professionals have expressed regret that the pandemic and the restrictions placed on our lives have meant that face-to-face meetings have not been as easily arranged as they might otherwise have expected. However, neither has expressed any concern that he or she has in any sense been hampered by these difficulties in carrying out sufficient investigation to be able to come to a robust conclusion. Both these professionals have had extensive involvement with the case, and each has had my judgment from the fact-finding hearing and ample time to consider it and assess the parents' responses. It has been a consistent feature of this case and a matter of considerable concern that Mr. Father has restricted access by the professionals to girl. He maintains this is girl's own decision. For all the reasons which are set out at length in my judgments, I do not accept that girl has come to any such decision, if indeed she has, without significant influence from her father. At the very least, Mr. Father has throughout been totally supportive of girl's decision and failed to take any steps in the exercise of his parental responsibility to persuade girl to the correct view about communicating at least with her guardians. In the circumstances, it is surprising and completely unjustified that Mr. Father should seek to criticize the children's guardian and undermine her conclusions by suggesting she has failed to establish a relationship with girl. She has been obstructed in doing so, and I am quite satisfied Mr. Father is primarily responsible for this. Nonetheless, this is not a nuanced case. The picture is very stark. My findings on the evidence are clear and well documented. The evidence of the toxicity of Mr. Father's parenting is overwhelming. The evidence of the harm caused to the children, and likely to be caused to the children, is clear. Mr. Father's blanket rejection of all criticism of him, his refusal to accept his parenting is in any sense deficient, and his outright refutation of any suggestion he should alter his views or behaviors in any way, are all expressly reiterated by him to date. He remains aggressively oppositional and confrontational in respect of opinions and conclusions with which he disagrees. He is less than proactive in communicating and engages with, and cooperates in, the investigations and these proceedings entirely on his own terms. In the circumstances, it is very difficult to see what more could have been done by either Dr. H.W. or Ms. R.W. in the additional time which it is suggested each should have spent on this case. Each has a duty to advise the court on the children's situation. That situation is clear, and has been clear for some time. Mr. Father has produced no evidence of any substance to add to the wealth of information available to the court and the experts. He gives no crumb of comfort with which the experts might have worked to see whether alternative conclusions or solutions might be available. In short, if the criticism leveled at the experts is valid, and I don't accept it is, had each devoted more time and resources to this case, Mr. Father has provided no grounds for suggesting their conclusions could have been any different. I am quite satisfied that both Dr. H.W. and the children's guardian have come to robust conclusions after adequate investigation and consideration of all the relevant evidence. I accept their evidence. It is clear to me, and I find on the balance of probabilities, that Mr. Father remains, wittingly or unwittingly, a toxic parent. I wish it were otherwise, as the residual affection which all the children have for him shows that he has, at some point in the past at least, been able to offer something positive to his children. Those relationships have now become dysfunctional as their father, completely blinded by his need to hurt Ms. Mother, subordinates their welfare needs to his need for revenge. He clings tenaciously to what is, at best, an irrational and delusional narrative. Mr. Father has been given many pointers as to the issues and ample opportunities to address them, with or without seeking assistance. Unfortunately for the children, his insight is still missing in action. He either does not see or does not care. Ms. Mother is not without blame. Whilst her frustration with Mr. Father and his behaviors is quite understandable, she has allowed them on occasions to overwhelm her otherwise fairly sound understanding of her parental responsibility. She has succumbed to the temptation to redress the balance by discussing with the boys inappropriate issues, and to post online, by way of bitter rebuttal, material which she acknowledges she should not have done. I do not condone this. The parties to these proceedings have long been aware of the mutual responsibility to keep confidential information obtained during the course of the litigation. Conversely, I accept she swiftly acknowledged her offense and took the posting down. Further, I am aware that much more detailed and potentially damaging information from these proceedings has found its way onto the internet in recent weeks. Ms. Mother has filed a statement detailing it. There is currently no evidence before me to conclude who has been responsible, nor is there any evidence to justify a conclusion that either of these parents may have been responsible. Much harm, intentional and unintentional, may be done by such illicit, ill-informed, irresponsible, and malicious interference in other people's private family affairs. Sadly, that in itself seems to be a positive incentive for many of those culpable. In the circumstances, I repeat my disapproval of Ms. Mother's actions, but I do not propose to take any further action on this occasion. It is further disappointing that Ms. Mother has not felt able to press ahead more proactively with the proposals to reignite some contact with girl. Her hesitation, given the history and Mr. Father's enduring attitude and influence over girl, is understandable. However, the assistance which might have been available from social workers and or the children's guardian, with possible prompting from the court, will cease as these proceedings come finally to an end. The more time has passed, the more difficult it has become, and the more compelling the need to provide girl with an opportunity to experience rational reality as a contradiction to her father's worldview, as Dr. H.W. forcefully points out. It is a shame, but we are where we are. Having said all that, it is a tribute to Ms. Mother's responsibility that she has been able to avoid discouraging or dissuading the boys from continuing their affection for their father. This, of course, is in direct contrast to the decline in the relationship between girl and her mother, which is a direct result of Mr. Father's failure to subordinate his own desire for revenge to girl's clear need for permission to have a positive relationship with her mother. I have been given no reason to doubt Dr. H.W.'s assessment that she loves her mother, but is not allowed by her father to acknowledge it. The children's wishes and feelings are complex. Boy 2 and Boy 1 clearly still enjoy their father's company, but they have, throughout most of these proceedings, been protected from the exposure to their father's false narrative, which has wreaked such havoc with poor girls' emotional welfare. They have been able to experience the reality of their home with their mother and Mr. New, and they have thrived there. To an extent, this will provide them some protection from what they may soon enough come to understand is their father's characterization of the dangerous and disordered home they live in. Unlike girl, they will have their own settled experience to contradict it. There is clear evidence they have hitherto enjoyed their father's company, and would want to continue to do so. However, they are young and impressionable and, as set out in my earlier judgment, and highlighted by Dr. H.W. and The children's guardian, there has been some evidence that Mr. Father had begun to try to influence them against their mother and Mr. New. Mr. Father has given the clearest indication that, given the opportunity, he will continue to do so. He told me that when the boys live with him they will have contact with their mother, as long as it is safe. The decision as to whether it is safe will be taken by him in consultation with the children. Given the history, I am confident the boys would only be allowed to consider their father's false evaluation of the risks. Their views and perceptions would inevitably be subject to the same bullying and manipulation, which has so influenced girls. There are many examples, historically, and during the course of the proceedings, which demonstrate clearly Mr. Father's intolerant attitude towards dissent and the resultant consequences. The boys do not have an adequate understanding of these issues, nor should they be expected to. As a result, they are ill-equipped to defend themselves from the likely attempts to distance them from their mother if exposed to the unrestrained and unmoderated false paternal narrative. Girl is 15. She is old enough to express a view and have it given serious consideration. Her expressed wish is to remain living with her father. I am quite satisfied that, objectively, this is contrary to her welfare interests. However, so much time has passed that she has become firmly imbued with her father's false narrative, and it is going to take some shifting. I feel she has been let down by the social services, who have failed to act in time to protect her, despite numerous approaches from the court and the children's guardians, and extensive evidence to demonstrate the harm being done to her in her father's care. It is now too late to attempt any extraction with which she is not in agreement, however unreliable her own assessment may be. It can only be hoped that, in the future, she will develop an understanding of the disordered influences which have played a part in her decisions, and come to a more rational and realistic assessment of her family's difficulties. All the children have an emotional need to be protected from adult issues and exposure to false and damaging narratives. Ms. Mother has shown some ability to recognize this and act responsibly. Mr. Father continues to demonstrate a determination to perpetuate his false narrative, and to ensure it is communicated to the children in furtherance of his own agenda. A move to live with their father would be catastrophic for the boys. It is almost certain their relationship with their mother would suffer in the same way as girls has. They would certainly not be permitted to continue to enjoy the good relationship they currently have with Mr. New. They would inevitably be exposed to, and clearly expected to subscribe to, their father's dysfunctional views, attitudes, and behaviors, all of which are detailed on the evidence in these judgments. I have to accept, with a heavy heart, that a change for girl to live with her mother and brothers is not currently capable of accomplishment without considerable trauma. It is likely that girl would simply not comply. If she were open to the idea, I would unhesitatingly promote it in her welfare interests. Sadly, the passage of time and the work done by Mr. Father do not make that a viable option for her today. The promotion of sibling contact is clearly in the children's welfare interests. It cannot involve Mr. Father in any way. They must be given the space away from the adult influences to regain the benefits of what are likely to be the longest relationships of their lives. Care will have to be taken to avoid the boys becoming proselytized to their father's cause by girl, and it is to be hoped that whoever supports such contact will be vigilant to prevent it. It is further to be hoped that the experience will open girl's mind to the reality of her situation. However, primarily the children must, if at all possible, be liberated to develop their own relationships on their own terms. I am satisfied that the time the boys spend with their father must be professionally supervised for the foreseeable future. Mr. Father has shown he is quite prepared to involve the children in his vendetta, regardless of the cost to them. He shows not a scintilla of insight into the harm he has caused, and he shows no inclination to develop any. If he can exercise his contact with the boys whilst resisting the temptation to indoctrinate them in his narrative, contact can clearly be of benefit to the boys. I'm afraid I am not persuaded he can be trusted to exercise such restraint when unsupervised, and I am not persuaded his own mother, however good her intentions may be, would be able to protect them should she be asked to supervise his relationship with the boys once the oversight of the court has been removed. This being a situation of his own making, I see no reason why Ms. Mother should be required to contribute to any consequential costs. Clearly there is nothing to prevent her offering to do so if she sees it to be in the children's welfare interests. The children have all suffered harm to some extent. The separation of their parents is always a negative in children's lives. Sometimes it is still better than the alternative. It is not necessarily an abdication of parental responsibility for parents to split up. It becomes a significantly more serious and reprehensible situation when the parents do not protect their children from their disputes, or worse still actively involve them. Here the boys have been shielded from the worst excesses of their father's vindictiveness, and appear to be coping well and thriving in their mother's care. The same is not true of girl. The damage done to her is starkly and poignantly set out in the evidence of Dr. H.W. and the children's guardians, and to some extent in the social work evidence. Mr. Father has invested significant time and energy over the last 3 years in poisoning girl's relationship with her mother and Mr. New by insistence upon and incremental elaboration of a baseless and destructive narrative. He has done a very effective job. It is clear he must not be afforded the opportunity to do the same with the boys. There is, of course, no such thing as a perfect parent. I am quite satisfied, for the reasons already set out in these judgments, that Ms. Mother is entirely capable of exercising her parental responsibility in the welfare interest of all these children. The odd glitch when she has allowed her frustrations to get the better of her notwithstanding, she has shown herself to be by far the more responsible parent for these children. Mr. Father, on the other hand, has shown himself to be a toxic parent. The evidence to support that conclusion is set out in great detail in these judgments. I do not consider it objectively to be in girl's welfare interests to remain in her father's care, effectively isolated from her siblings, her maternal family, and exposure to rational reality. Unfortunately, the situation has become so entrenched that the harm likely to be caused by attempting to extract her against her expressed wishes is likely now to be greater than the additional harm which will be caused by leaving her where she is. I am satisfied it is in the boys' welfare interests their contact with their sister should be insulated from their father's agenda, and that their father should, as far as possible, be prevented from having access to them other than in a professionally supervised environment. I propose to make an order that there be no contact between Mr. Father and Boy 2 and Boy 1 save where it is professionally supervised, if necessary at his expense. I will make further orders emphasizing the need for Mr. Father to observe the spirit, as well as the letter of the strictures, and resist the temptation to test the boundaries. I do not propose to make any order in respect of girl, save that her father should make her available for contact with her brothers. I will not create a situation where it might be possible to interpret my order as an endorsement of her placement with her father. Mr. Father already shares parental responsibility for her. I appreciate the orders I do propose to make engage the family's Article 8 rights. Those rights are balanced as between adults and children. Children are entitled to a family life, where they are secure and nurtured and protected from harm. I am satisfied the orders I propose to make in respect of all the children are both necessary and proportionate in their welfare interests and to protect them from harm. The order accompanies this judgment. I do not propose to schedule a further hearing unless one of the parties notifies me within 7 days of a request to do so, together with the reasons why it is suggested it is necessary. Any further applications in respect of any of these children will be reserved to me if I am available. This judgment will be formally handed down on May 18, 2021 at 10 a.m. at the County Court at Chelmsford. All parties are excused attendance, the text having been circulated in advance. The time for appealing this judgment will commence then and expire on June 2, 2021.